my Lord have already delivered the judgment, which has been tested before the Supreme Court and the revenue appeal has been dismissed. May I have your Lordship's permission to take up the matter at 2 p.m. my Lord?
2 p.m. today is not possible because let it be tomorrow. Let it be there in the list.
My Lord,
I'll pick up the matter tomorrow.
I'll take my chance, my Lord.
You please inform me.
Your Lordship, I am from the department.
Yes, he is there.
I'll request the Lordship that let the order be passed and we can list that matter. The order which has been reserved by your Lordship. After
That's what
passing.
he was telling me. If I'll pass, you will be doubly covered.
I'm grateful. I'm grateful, man.
Lordship.
Mother expired, Lordship.
Mother expired when?
9 September, my Lord.
9 September. 9 September. Huh?
Restoration matter.
Huh?
Restoration.
Restoration. When it was dismissed? 23. It will come. Don't worry.
Item
23. Yes.
Item 93 million. I pay an adjournment.
93. Interim order is there. Huh? Who? Anybody is there from the other side? No, you have to tell the other side. Otherwise,
Yes, no, go state by.
huh?
State.
State. Interim order is not there? Is there or not?
Yes, yes.
Interim order is there. Let us see then. I'll adjourn. Note kar adjourn, but don't worry.
Item 98, your Lordship. I had challenged the order taking cognizance in a complaint case, which was converted to FIR. In the meanwhile, final report has been submitted. I may pray only your Lordship may take note of and distribute.
Okay. Right.
That
90, 95.
98, your Lordship.
90.
Your Lordship's permission I am filing. I have just marked it for your Lordship's time period. The two marks.
I'll simply say in view of the recent development.
Well, that your Lordship may kindly just take note of the fact that final report has been submitted. The second marking portion.
95, no?
98, your Lordship.
98. Right on. 98. In this petition, petitioner has challenged the final report. Challenge the prosecution initiated against him by the registration of the Hon'Ble PS case number 294 of 2023, corresponding to CT case number 927 of 2023, pending in the court of SDJM Bhubaneswar. Meanwhile, after investigation, the police has laid down the charge sheet on 19/1/2023, closing the case being.
And that will be final report, not charge sheet. But once it is closure means.
Yes. Report under 173 CRPC. CRPC closing the case, being misconception of fact.
Insufficiency of evidence.
Insufficient evidence. In view of the aforesaid development, the same is distributed.
107 lots.
107.
107 lots. This does pertaining to release of the seized amount of 25 lakhs lots.
Yeah.
May I print it tomorrow, lots? I'm expecting the instruction today, lots.
It's all right. When it comes, you just tell me. Here. 50, sorry?
I don't know, but 50 can be taken up 2 weeks after.
Adjourned. It will be adjourned. I don't know when it will be taken. Okay. Adjourned.
Item 7 million.
Is there any interim order? No interim. Okay. Adjourned. Yes. 109. 108. No interim order?
No.
Okay. Adjourned.
Pardon to mention item 18. Lordship prayed for next week.
Not next week. Interim order is there?
No, BLPL matter.
Adjourned. It will go to November last.
Pardon me, lords. Item 7 million.
7.
Clear admission millions.
Yes.
In this case, millions informant very recently married millions. He could not able to come millions. Matter has been compromised. After vacation, recently marriage is
17. What do you want? Bail application. Why are you moving the bail application? Bail application, why are you seeking adjournment? I tell you. Huh? Sorry? On request? And thereafter, don't complain, your matter is not listed. Somehow we adjust and all the matters are listed, you want adjournment.
Item 29, my lord.
29.
29. Permitted to withdraw, my lord, with a liberty to file after examination of material witnesses.
Then comes for the petition. 29. 29?
29.
Withdraw the petition to renew the bail fee after the material witnesses are examined. It is expected that the trial court can do well to see that the material witnesses are preferentially examined over the formal witnesses. With this observation, petition is disposed. Yes.
Okay.
Yes.
I may be permitted to mention Mullahs.
1 minute.
I'm appearing through VC Mullahs.
1 minute. Physical mentioning. Yes. 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 What do you want then? It will be taken up. Wait. I don't know whether hearing can take place or not. Because the bail matters has to be given preference. Let it be, let us see, if the service is sufficient, then I will recommend. With that, the judgment of the Supreme Court, whatever you are saying, the service is sufficient. Day after tomorrow, once it goes from the list, I don't know. Let it be there, wait. Once it goes from the list, we don't know when it will come. Wait, yes.
I may be permitted to mention Mullahs.
Yes, sorry, yes.
No, Mullahs. Mullahs, it is with respect to bail application number 5616 of 2024. I know it is bail application, but I have earlier been mentioned about it before you lot.
What do you want? What do you want? You tell me.
My lord, I want the listing of this matter because last time when I mentioned
take it from me that in this week, all the bail application hearing will be completed.
May I submit one thing,
It
Mullahs?
will be listed.
Much obliged. May I submit one thing?
Friday, you wait till Friday, you see your matter is listed.
It's 5616 of 2024, Mullahs.
5616.
Much obliged, Mullahs. Much obliged.
Pardon to mention, my lords, from BC, my lords.
Yes, sir.
Item 12 has become infructuous, my lords. Trial
Item
has
12.
concluded, my lords.
Yes.
Item 12.
Thank you. Yes. Start. Item 2. Item 2. Last time also none appeared. None appeared last time also. In the interest of justice, you are adjourned. Right up. The matter was taken up on 7/8/2024. None appeared on that day for the petitioner. Therefore, in the interest of justice, the matter is directed to be listed today. Even today, none appeared for the petitioner. It seems the petitioner is not.
Copy of charge sheet we have not filed, my lord.
Interested to proceed with the matter. Moreover, the copy of charge sheet supposed to be filed by the petitioner has not been filed. Therefore, the petition is dismissed. Yes. Then confident petitioner submits that the matter has become infructuous, disposed of as a factors. Yes.
Although I have filed the challenge the order of cognizance, but as I found no case, may I pray permitted to surrender before the court below and to move for bail.
Right. When do you want to? Sir?
Within 2 weeks, my lord.
Although the petitioner had challenged the order dated 16/11/2023 passed by JMFC Jatni in GR case number 748 of 2018, whereby cognizance of offences against the petitioner had been taken. However, Mr. Chan at this stage submits on instruction that his client would be appearing before the court and raise all the points at appropriate stage before the trial court. The petitioner shall appear before the court on or before
Any day, within last week of coming month.
20th of October, on or before 20th of October, and resort to the remedy available to him under law. He is on bail.
No.
Till then, no coercive action shall be taken. Since you have undertaken, it made clear that no further extension of time for appearance will be given. Yes.
Finally, urgent to next week, personal difficulty.
Personal difficulty, it will be urgent, but not next week. Urgent on the request, please the matter. Item 6.
Item 6, prefer one Passover.
Passport today may not be possible, madam.
One Passover list.
But it may be very difficult, therefore I'm saying. I'll put it next week.
My senior
I'll put it next week. Put it next week.
published list.
Passover today may not be possible, therefore I'm saying, yes. Item 8. Yes.
No, sir, this is again a revision.
So 8, I'm praying for Passover. Let's kindly keep it to next week.
Passover may not be possible.
They kindly take it on next week.
May submit, my lord. In this case, my lord, they are challenging orders by which their discharge application has been rejected, my lords. My lord, if lordship see the page 30 of that impugn orders, page 30 of lordship brief, my lords, it says that the charge has been framed against other accused persons. In the meantime, 2 witnesses have already been examined by the court, my lords. In this case, 9 accusers there, my lord, and the petitioner is 1, my lord. But out 8 other persons, the London trial court has recorded at page 30. The charge has been framed against the other accused persons. At the meantime, 2 witnesses have already been examined with court. Let him take instruction that.
Yes, sir. Take instruction if that is the case.
Then they can raise all these points.
So that you can raise all these points because charge has been framed for the other accused person.
The one problem, my senior will argue, Mr. Dhal will argue in this case, Your Lordship. I will take instruction, keep it next week, Lordship.
Next week. But you whatever Mr. Das has said, you note it down and tell your senior. Okay. What did you understand? What he said?
Page 30, page 30.
What have you
Page 30, 2 witnesses examined.
2 witnesses have been examined. Who are the other accused person and charge has been and everything is over. So therefore you can also raise all these points there. Yes.
Yes, sir.
9. Yes.
9, my lord.
Yes.
On 31/7/2024, my lord. Order dated 31/7/2024, my lord. Nobody appears, my lord. Then this honorable court directed the advocate for the petitioner to
stage of trial.
Stage of trial, my lord. But since, my lord, again, my lord, nobody is appear, my lord. Since, my lord, the copy is not served, my lord, the state council, my lord. That's the problem, my lord. I have downloaded 1 copy, my lord. I'll take over next week. Nobody is appearing, my lord, for the 408 offense, my lord. On custody since, my lord, 2023.
Bail matter.
Bail matter, my lord. Nobody is, my lord, come.
That's the whole difficulty. Nobody appeared on 9/11/2023. Thereafter, again on 30/7/2024, nobody appeared.
Last occasion, somebody appeared.
Somebody appeared and request for adjournment, and today also nobody appeared.
For traveling master offense, 23, my lord, he is in custody.
23,
my lord. Last rejection order, my lord.
He is entitled for bail, then I'll grant bail.
Nobody is, my lord, moving, my lord, for that is, my lord. Liberty, even if not dispose of the case, my lord, renew his prayer.
I'll just pass over, let us see, because this is very...
Pass over, my lord. 2 p.m.
2 p.m. Because see, he is entitled to bail, nobody is coming forward for some reason you may be knowing.
2 p.m. my lord.
2 p.m.
Pardon to make a mention, Lordship, item 6, interim order to continue.
Entry mode next week, okay, entry mode.
Listeners.
Yes.
Marriage 7 years back. Charge sheet submitted, my lord.
Yes.
I am read out one statement.
Custody, you tell me the custody.
Custody since, my lord, 25/3/23.
25/3/2023. Okay.
I am read out one statement, my lord. Kapila Kishore Parida.
Yes.
Mu Swanso, Anchol grammar more Poribar Soito Rochi.
You have CD with you?
My lord.
Yes.
ଗତ 2016 ମସିହାରେ ମୋର ପୁଅ ବିଜୟ କୁମାର ପରିଡ଼ାଙ୍କର ଖୋର୍ଦ୍ଧା ସୁଆଂଶ ପଦ୍ମଚରଣ ପାଇକରାଙ୍କ ଝିଅ ପ୍ରଣତି ପରିଡ଼ାଙ୍କ ସହ ହିନ୍ଦୁ ପରମ୍ପରା ଅନୁସାରେ ବିବାହ କରାଇଥିଲେ। ମୋ ପୁଅର ଗୋଟେ ପୁଅ ଅଛି। ବିବାହର କିଛି ଦିନ ପରେ ମୋର ପୁଅ ବୋହୂ ମଧ୍ୟରେ ଅଧିକାଂଶ ସମୟରେ ପାଟିତୁଣ୍ଡ ହେଉଥିଲା। ଗତ 23/3/2023 ରିଖରେ ମୋର ବୋହୂ ପ୍ରଣତି ପରିଡ଼ା ବାରମ୍ବାର ବାନ୍ତି କରିଥିଲା एणु मु पचारिबारे से आम घरे थिबा पोकमरा औषध पी देइछन्ति बोली कहिथिले एहा परे मु मोर पुओ अन्य संपर्कीय माने मिसी मोर बोहू को रणपुर डाक्तरखाना को नेई चिकित्सा कराइथिली
I understood you.
Madam.
You approached many time before this court.
yes
It is rejected.
no ये first time my lord
What is this then this flag? What is his name? You are Sita Parida.
नहीं Sita Parida is the mother-in-law. He is moving anticipatory bail. He is the husband.
She got the bill.
Yes, I don't know.
No,
Ye,
madam.
so far as the
For preliminary charge sheet is submitted against the petition, my lord. And under section 170, sub 8, my lord. The another accused Sita Parida, my lord, till yet he is absconded. For that reason, the case inquiry, my lord, final last occasion she directed me to take instruction regarding something final charge sheet, my lord. Final charge sheet could not be, my lord, submitted as because the one of the accused absconded, police searching him, my lord. Searching her. That is the report, my lord.
1.5 वर्ष ये आगे रोइलानी
Tell me what is the evidence against him?
My lord.
But the what he has read it out is that
Kopilo Kishore.
Kopilo Kishore.
My lord, the chemical report I have obtained, my lord. That is, my lord, the poison, my lord.
Poison, but who here? She has herself taken or it is administrated?
My lord. गत 23/9 फोन कली फोन करी कहला कि बो देढसुर जा सासु ससुर मते बहुत गंजाणा देउसंती अलक्षणी तू आसिले
Petitioner is inside custody, my lord,
Yes.
since 10/10/2023.
10/10. Okay.
On the last occasion, Lordship has heard this case and directed my learned friend to take instruction with regard to the mental condition of the present petitioner.
Yes.
Allegation is that she, being a mother, killed her 5 days daughter.
that is the allegation, my lord. Totally, my lord.
ପାଞ୍ଚ ଦିନର ଛୁଆକୁ
her own
Daughter.
daughter, my lord.
ପାଞ୍ଚ ଦିନର ଛୁଆକୁ
Mental
ମାରି
condition.
Mental question, my lord, time doctor, my lord, sending her to the,
No, you have you any report?
my lord. It did not report, my lord, exact report has not come, my lord. But in fact, my lord, they have the,
Get the report.
my lord,
Get the report.
though they have sent, my lord, instruction, my lord, with some of the reports, my lord,
What is that?
my lord.
No, from doctor's report.
Yes, doctor.
Doctor's
Psychiatrist.
report, no, no.
Jail authority, what the jail?
DTH ରେ ଆସିଛି କଟକ ପଠେଇନି କଟକଟା ଆସିନି
Asini.
my lord. ଆଉ
The,
ଡେଟ୍
the state council submits that the report regarding the mental health condition of the petitioner has not yet been received by him.
received, my lord, but DTH, my lord, the district hospital, my lord. But I have to obtain the same, my lord, from the AC Medical College.
He would seek appropriate instruction on the next date of hearing and next date of hearing. The allegation against since the allegation against the petitioner is that she has killed her 5 days daughter, a daughter of 5 days old.
5 days.
Old. Her mental condition is not stable as per the counsel for the petitioner. In that regard, appropriate report from a psychiatrist is to be placed before this court by next date of hearing. This is the matter after 10th of October. After 10th of any day.
After 10th.
Obviously, 1 year.
Hello?
1 year custody will be over after 10th. Easily. Yes, next.
13.
Yes, sir. 12. Withdraw. Huh? In fact.
Two data.
13, I'm appearing on behalf of,
Disposal. Or 12
behalf of
disposal.
Mr. appearing on behalf of Mr. B.R. Tripathi. Lord, this matter be taken up on 25/9/2024 because a similar matter arising of the same FIR has been posted to that day. So both the matters may be taken up together.
Another accused.
Yes, ma'am. Co-accused.
The bail application of co-accused is listed on co-accused being number
Bill letter
1949 of 2024.
Arjun 25, 2059.
29. This one 20. Yes. Next.
Obliged.
14.
May it please your lordship. Item number 1 for and through VC, my lord. Previously, your lordship granted interim bail to the petitioner, your lordship. In the meantime, the petitioner surrendered and he obeyed the order of this honorable court. I am submitting the surrender certificate, my lord.
Submit.
Your Lordship, my associate submitting.
Mr. Sahul and counsel for the petitioner submits that pursuant to the order dated 11/7/2024, whereby interim bail was granted to the petitioner has surrendered and is filing the surrender certificate, which is taken on record. Leaves the matter after 2 weeks for a hearing. Yes.
I will file the case law in this matter.
You file whatever. Huh?
Yes. Grateful, Your Lordship.
After 2 weeks, main matter.
14.
15.
May I finish, my lord? On behalf of SS Plus, kindly taken on next week.
Not next week. It will go to
Kindly pass over.
It will go to December. Urgent. Request December. Yes.
Oblige, my lord.
16.
Bail matters you are asking and urgent.
Beg pardon, my lord. Beg pardon, my lord. In item number 14, my name is reflected wrongly, Your Lordship.
Correct. Okay.
Cause title.
Yes, yes.
My lord, the charge sheet submitted under section 498, 498A, charge sheet submitted against the petitioner,
Yes.
498A, 304B, 306 of IPS, Your Lordship.
Okay. Your husband,
Yes, Your Lordship.
custody since
Charge sheet since, my lord, 7th of December 2023. And he was in custody since 10th of August 2023.
Huh?
10th of August, 10th,
10
8, 2023.
in custody.
Yes, Your Lordship.
Yes. Charge sheet filed on.
Held on 7th of December.
Okay.
7/12/23.
Okay.
Well, here in this case, my lord, the deceased committed suicide by hanging, Your Lordship.
Yes.
And the doctor,
What happened, my lord? I read out 164 statement of one of the witness, my lord. 164.
164.
My lord. So
How many witnesses you have examined? 164?
five.
One.
One.
164 one witness.
Yes.
मते 24/7 ମାନେ डेट ऑफ ऑकरेंस वाला 24/7 ସକାଳ 7ଟାରେ ମୋ ଦିଦି ଡିସିଜ ଶାନ୍ତିଲତା ମତେ ଫୋନ କରି କହିଲେ କି କାଲି ରାତିରେ ତାଙ୍କ ସ୍ୱାମୀ ଆଲୋକ ପିଟିସନର ଦିଗଲ ତାଙ୍କୁ ବହୁତ ମାରିଛନ୍ତି, ସେ ଉଠି ବସି ପାରୁନାହାନ୍ତି, ଝାଡା ବି ଯାଇ ପାରୁନାହାନ୍ତି। ମୋ ଭଉଣୀ ଗର୍ଭବତୀ ଥିଲା, ତାଙ୍କ 4 ମାସ ଚାଲିଥିଲା। ସେ କହିଲେ କି ତାଙ୍କ ସ୍ୱାମୀ ତାଙ୍କୁ ପେଟକୁ ମାରିଛି ଓ ତାଙ୍କର ବ୍ଲିଡିଂ ହଉଛି, ସେ ଆଉ ସେଠି ରହିବେନି ବୋଲି କହିଲେ। ମା ବାପାଙ୍କୁ କହିଦେବୁ, ତାପରେ ଫୋନ କାଟିଦେଲେ। ଆଉ ଥରେ ଫୋନ କରି କହିଲି କଣ ହୋଇଛି, ଭଲସେ କହିଲେ ସିନା ବାପା ମାଙ୍କୁ କହିବି। ସେ କହିଲା ମୁଁ ଆଉ ରହିବିନି, କେତେ ଥର କହିବି। ତାପରେ ସେ ତଳେ ପଡିଯିବା ଭଳି ଶବ୍ଦ ଶୁଭିଲା, ଫୋନ କଟେଇଦେଲା। ମୁଁ ଆଉ ଫୋନ କଲାରୁ ଉଠେଇଲା ନାହିଁ। ମୁଁ ଭାଇଙ୍କୁ ଜଣେଇଲି। ସମସ୍ତେ
but the doctor,
what happened in this case, my lord? As per case, my lord, the husband, the petitioner assaulted brutality her wife, and she was pregnant by the time, my lord. She went and dead body found after 15 days, 17 days from another place.
but the doctor examined, doctor opined that
See the
my lord,
no external injury.
she was pregnant, my lord.
The postmortem report, my lord.
During the investigation, statement of one of the witness. What is the name?
Jibolata Digal.
Jibolata Digal. Under section 164 CRPC, which was read out in the court. I'm not convinced. I'm not inclined to enlarge the bail at this case in view of the nature of accusation against him. However, devotee is granted to the petitioner to renew his bail free before the court below after the examination of the material witnesses. The trial court is directed to be able to see that the material witnesses are examined preferentially over all other witnesses. Yes. Next.
19, 17,
17, 18, 19.
My plea, Your
Yes,
Lordship.
sir.
Petitioner inside custody since Your Lordship 4/12/2023.
12/23. Okay.
My lord, he was charge sheeted under section 302/34 IPC, Your Lordship.
Yes. CD is there.
My lord, item number 19.
19.
19. My lord, CD is there, my lord.
Yes. Yes, sir.
My lord, facts of the case on the
Netram Das.
Present petitioner is the Netram Das, your lordship.
Yes.
And here man accused is the Arun Das, your lordship. Man accused, man assailant is the Arun Das, your
Let us
lordship.
see.
Oh,
What
my
are the-
lord,
what are
this
the-
petitioner Netram Das
Huh.
in CD, my lord, on interrogation, my lord. Interrogation, the accused Netram Das on interrogation, he admitted he is guilty to committed the crime and stated that on the day of occurrence, that is 19/11/23, 19/10/23 morning, he along with his grandson Arun Das. Arun Das is man.
This is the confessional statement of who?
It is interrogation, my lord, in the investigation.
Oh, confessional statement of accused.
My lord. They
What
have-
else you have?
My lord, this is Rajesh Bera by means of iron pipe, and this person tied his neck by means of rope and left him in severely injured condition. Subsequently, the deceased has died during undergoing treatment at Ninato Bensha.
That's the statement of the accused himself.
Yes, my lord.
What else you have?
That is, my lord, and the co-accused Arunadas weapon has been seized from this Arunadas, my lord, admitted.
Hey, what are the evidence against this man? Apart from his own statement, confessional statement. That is under in the custody of the police, he has given statement. That is neither here nor there. Have you collected anything?
No, my lord, regarding specifically regarding that.
Next
this
week, properly read it. And 302, you must
Yes,
read
my
it.
lord. Yes.
Must tell me anything next week. Next week.
My lord, except the,
Next week.
yes.
Because
Yes.
APSC, if that is the only evidence, then you are out. If apart from that, if anything else,
Mr.
tell me.
Mr. Babu, can
Next week. Next week, be ready with next week.
Application on the basis of sniffer dog.
Sniffer dogs.
Sniffer dog, he has identified that house of the present petitioner and leading to discovery that iron pipe was also seen from the program.
That's right, but what have you, you are going to examine
No other.
dog under 164?
No other.
Then
No, there is no any other.
what else? You just read it out. Because it is 302. We can't take it so lightly. Okay. Next week, please
Well-
read it. And just the one thing you have said, sniffer dog, this thing. And what else you have collected?
Whether there is other.
Other connecting evidences. Yes, next.
20.
20.
Sir, on the last occasion when DNA report was sought for,
Just pass it.
as the petitioner was disputing the paternity of the child,
That's a DNA report.
my lord.
Submits that the
My lord,
counsel for the petition submits that the prosecution has sought for DNA report
My lord.
of the child alleged to have been born out of the yes.
DNA report is excluded, my lord. DNA report is excluded.
No, you have got the DNA report.
Yes, my lord.
He's not the biological.
Not the biological.
But
But-
the thing is that it's not a determination of that the paternity of the child.
My lord.
Whether the offense was committed or not, 376.
That's a part, but why have you asked for the DNA report?
My lord, as he was disputing the paternity of that child
Then
born out of.
That evidence is there.
Who has filed?
He is not the
My lord.
biological child of this.
My
No,
lord,
that is excluded.
My lord,
That will be decided at the time of the.
That's not paternity, but
May not some-
see, the suspect is he has impregnated this girl. That is why. Now you yourself have got the DNA report, which suggests that he is not the father.
He is not.
Then that suspect is diluted.
my lord.
The suspect is
But
diluted.
the.
So at least he is entitled to bail. Conviction is something different. Entitled to bail.
Who that
Yes,
We are, we are only considering bail.
Yes, my lord.
See, the suspect which you had, strong suspicion which you had, that is being diluted because of your own DNA report.
my lord.
You consider that if you want to address on this issue also, you can address. But you got he is not, at his instance, DNA report hasn't come. It is you who has got it.
That I will check.
My lord, to that,
Identification for daily.
Whether he has asked for it.
That is I will check.
my lord, to that effect, I have.
What last time what impression was given is, it is the prosecution police
Police has,
on their own accord
my lord.
went and got that DNA report.
As per 164 statement, my lord, the relationship, the physical relationship has been forcibly done by this petitioner. But and excluding when the victim has become.
Now you have created a doubt on that.
What's my lord?
My
You
both.
by getting that DNA report, you have created a doubt.
Though the victim was pregnant and
That doubt, because of this benefit of doubt,
yes.
at least at this stage, he is entitled.
Yes, madam. Yes,
Whether
madam.
she will be acquitted or not, that is a different story.
Yes, madam, that is separate. Your
Right
lordship,
on. What 164, read it out.
Madam.
What is the age of this boy?
My lord.
25,
He also 25. The girl is
21.
21.
ଗଲା 25
Consensual relationship, madam.
ଗଲା 25 ଡିସେମ୍ବର 22 ତାରିଖରେ ଭୂପତ ଗାଁର ବଲ୍ ଖେଳ ହେଉଥିଲା ସେଠି କନେଇ ବକ୍ଷର ଚନ୍ଦନ ଖଡିକା ଦିସ୍ ପିଟିସନର ସହିତ ମୋର ଦେଖା ହୋଇଥିଲା ସିଏ ମତେ ତାର ଫୋନ ନମ୍ବର ଦେଲା ମୁଁ ତାର ଫୋନ ମୋର ମତେ ଫୋନ ନମ୍ବର ଦେଲା ମୁଁ ଫୋନ ମାରିଲି ଆମେ କଥା ହେଲୁ ଗଲା ବର୍ଷ ରଜ ପରେ ତାରିଖ ମନେ ନାହିଁ ସେ ମତେ ଡାକିଲା ଖୁଣ୍ଟାକୁ ଡାକି ସେ ମତେ 11 ରୁ 12ଟା ବେଳକୁ କୁମ୍ଭୀରା ହଡିକୁ ନେଇଗଲା ମତେ ବାହା ହେବ ବୋଲି କହି ଜବରଦସ୍ତ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା
Child is born out of this relationship. That's what the delegation.
She said that, madam.
It is alleged that the statement of the victim, prosecutor, under 164 CRP was recorded, which was read over extensively in the court, read over extensively in the court. It reveals from the statement that the petitioners and the victim were in relationship, and the victim has stated that she was forcibly sexually assaulted, as a result of which she became pregnant. She became pregnant and subsequently delivered a baby girl.
Yes, madam.
Baby girl or
Baby girl.
baby girl? Delivery girl. And during girl. And, the petitioner, although promised to marry her, however, he wriggled out of his promises. Therefore, the FIR was registered. During investigation, the police had sought for a DNA report of the child, and the DNA report reveals that the petitioner is not the biological father of the child. Regard being had to the aforementioned and the period of custody from
8 to 2024, 8 February.
8 February 2022. I'm inclined to that because
I have cited on judgment. Can we?
Forget about judgment. Don't complicate.
Okay.
Give that judgment if you want. Right. The counsel for the petition also cited this judgment. Which paragraph? Order is not a judgment.
That Mohammed Ansar Mohammed versus State of Rajasthan.
It's not a judgment, madam. It is an order.
It's regarding that where consensual relationship breakdown 376 2N is not, madam.
We submit that citing is order.
The citation is 2022 live law SC page number 588. Okay.
Yes.
21.
Your lordship, I mean, basically,
Yes.
petitioner is in custody since October 2024.
Yes.
And last occasion, your lordship directed to file a comprehensive affidavit regarding the antecedent, my lord. And there is one antecedent not in similar nature, my lord.
Sorry?
Not similar nature, my lord.
One incident
Antecedent.
is there, my lord, in other offenses. Other offenses. My lord.
No, what is the case?
Yes, my lord.
Case 20B to C, 50 kg ganja.
50 kg contraband ganja, my lord, against from this
50 kg.
petitioner with conscious and exclusive possession, my lord.
Huh?
From the with
On-
conscious and exclusive possession from the Renault car, my lord.
Okay.
By this petitioner.
And Dicky, my lord.
He's in custody.
And mandatory provision 52 and 50 not
He doesn't
compliant.
have any antecedent, according to you.
My lord, one antecedent.
So like,
Not similar nature.
I don't 50 kilo custody from 17 to 2024, subject to verification of. Yes.
22.
Your Lordship, the petitioner is in custody since 19/6/2023, my lord.
Sorry?
19/6/2023, my lord.
Yes.
The last occasion, my lord, was directed to file the deposition copies of the witnesses, my lord.
Yes.
I have already filed, my lord.
Yes.
And
What,
this,
what are the
PW,
offenses? 302.
no, my lord.
376(3), my lord.
376(3), my lord.
Read out.
And 6 Pox Act, my lord.
Yes.
Well, in this case, the PW10 is the victim, my lord.
PW 10.
10, my lord.
Yes, read out.
Well, the statement of the victim and our 164 statement, both are contradictory, my lord. The informant is my mother. I am the victim in this case. I know the accused. The occurrence took place on 20/11/22.
Yes.
On that day, while I was proceeding to the shop of stitching up my school bag, accused came and asked me to accompany with him to the spot. But instead of going to the shop, he took away me to Bhubaneswar. In spite of repeated requests, he told me that he lost me. When I asked him to leave me, but he denied. We both live at Bhubaneswar for 8 days. Thereafter, he took me to Kerala and confined me there. There, he had kept sexual relationship with me. When I protested, he assaulted me.
Yes.
One day, the accused left his mobile and
I read it out completely.
my lord.
Yes.
Then, my lord, 164 statement is totally different, my lord. Then your lordship kindly see the page 13.
Yes.
The rejection order of the Honorable Lord Trial Court, my lord.
Yes.
He has admitted towards last, my lord. Even if it is presumed that last, even if it is presumed that the physical relationship between the accused and the victim is consensual in nature, but considering the fact that the victim is a minor and
What is the age of the victim?
Age of the victim is, he stated 15 years, my lord.
15 years, 1 month.
But the age,
You are 41.
my lord, but the age has not been proved by the lord.
Whatever, you are 41, he
My
is
lord.
15. She has, in the court, she has deposed against you very specifically.
My lord.
And
my lord, kindly
I don't
see
think-
the 164 statement of the victim, my lord. The 164 statement.
Yes. Read out. Read out, read out.
ମୁଁ 2022 ମସିହା ନଭେମ୍ବର ମାସ ସ୍କୁଲ ଛୁଟି ଥିବା ଦିନ ବା ରବିବାର ଦିନ ମୁଁ ସକାଳେ ମୁଁ ପାଠ ନ ପଢିବାରୁ ମୋ ମା ମତେ ମାରିଲେ। ତାପରେ ମୁଁ ଘରୁ ରାଗି କରି ବୁଲୁ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ମାଇଲ ରାଗି କରି ବୁଲୁ କାମ କରୁଥିବା ଜାଗା ଚୁଡାଖିଆକୁ ଯାଇଥିଲି। ତା ପାଖରେ ଯାଇ ପହଞ୍ଚିଲି। ସେ ମତେ କୁଆଡେ ବୋଲି ପଚାରିବାରୁ ମୁଁ କହିଲି ମା ମତେ ମାରିଲେ, ତେଣୁ ମୁଁ ଘର ଛାଡି ପଳେଇ ଆସିଛି। ଆଉ ତୁ ମତେ ତୋ ସ୍ତ୍ରୀ ତୋ ସହ ନେଇଯା। ତାପରେ ସେ ମତେ ମନା କଲା। ମୁଁ ତେଣୁ
You are already married?
Yes, my lord.
they are both the petitioner and his wife. They are staying separately since last 10 years.
Then, all right. You repeat your bail application. Petitioner is against by the order dated 21/7/2023, whereby his bail has been rejected. Subsequent thereto, material witnesses have already been examined by the prosecution.
I for the informant, my lord.
In prosecution. In view of the aforementioned development, the petitioners are in the I am not inclined to entertain the bail application of this thing. However, the vote is granted to the petitioner to renew the bail for the court below. If the bail is moved, then can be continued on the example.
Well, out of 33 witnesses, only 10 witnesses are examinable.
Material.
Or also target, otherwise I will again renew my PR.
6 months. If material witnesses would not be examined, now within 6 months, you can take it. Yes, next.
23.
Offense under section 302 and 34 IPC, my lord. Section 9/8/2023.
In this case, my lord, some of the vital witnesses are already been examined. Lordship kindly taken of this matter 1 week after. In the meantime, I will file the deposition court.
Maybe you go to that court.
My lord,
Go to the trial court.
My lord, in between 6 months has been completed. More the witnesses might have been examined, my lord.
Petition is agreed by that.
as per
petition is
my
agreed by
as
the
per my
order.
instruction, my lord, the only one eyewitnesses, that is Beatles of shopkeeper, he become hostile, my lord. In this case,
Therefore, you may get bail by the High Court.
Another eyewitness
one
is
week-
there, 164 statement is there.
1 week after
No.
deposition copy guda nahi asile.
I will not examine all deposition and all, right? Petition is agreed by the order dated 13/2/2024, whereby his bail plea has been rejected by the trial court. He is one of the accused in the FIR number Kurunja kya hai, PS case number so and so for alleged offence under section 302/34 IPC. Meanwhile, the material witnesses have already been examined. In view of the aforementioned development, the petitioner is given liberty to renew the bail plea before the trial court. If such bail plea is moved, the same shall be considered on the basis of material available on the court. With this observation, the petition is- Okay, next.
24.
Item 24, Millard. There is a flag V kindly similar. Reason of petition is there on my name, Millard. Pray for tomorrow, day after tomorrow or next week, Millard. Flag
No
V.
question of day after tomorrow. You argue it or it will go to November last week or December. Argue it. If you have a case, you get the bail. Otherwise, it will go to November. Argue.
Millard,
Flag?
flag V, Millard. There
V,
is
V for Bombay. V.
V.
Okay.
Reason of petition, Millard. Millard, 51 kg, 30 grams NDPS. He is in custody, Millard. 10/12/2023, Millard. 10/12/2023.
Recovery?
Recovery conscious possession, Millard.
From Hyundai Santro car exclusive possession.
51 kilo.
My lord, 51 kg, my lord.
No previous case.
So 51 the standard.
Yeah.
51
10/12/23.
custody from 10/12/2023. Subject to verification of identity. Okay.
My name may be reflected, Millard.
Name.
Sarath Kumar Jain.
Sir.
25.
Obligable.
25, my lord, the other day, while hearing this case, my lord, lordship has directed me to file the charge sheet, copy of the charge sheet. I have filed it, madam. The co-accused persons has been released on bail by the learned court below. All of the co-accused.
30394 120B 411.
Aye.
Yes. Yes. What are the allegations against you? Who are you?
I'll-
You are Krishna Naik.
Voter I card gote DL ଆଉ 4000 ଟଙ୍କା ATM card ନେଇଗଲେ 4 ଜଣ ବୋଲି
Mobile phone, gold chain, petitioner sold that gold chain and mobile phone to.
How many cases are there against you?
My lord, that
Four
is reflected at page 10, my lord.
Four numbers.
Page 10 of the rejection order, my lord. Page 10 of the brief. Say 379 case again, 379 case.
Oh, then you are habitual.
My lord.
You are habitual. What is the stage of these cases?
19 ବର୍ଷର ପିଲାଟା।
No, 19 ବର୍ଷ ପିଲା, then they are menace in the society, I tell you.
19 ବର୍ଷ ପିଲା ତାପରେ co-accused confession ରେ ଆଜ୍ଞା implication।
No, what is the stage of these cases which are there against you?
ତାଥିରେ ବେଲ୍ ଅଛି ଆଜ୍ଞା ସବୁ। ବେଲ୍ ଅଛି ଏ କେସରେ ବି ଆଜ୍ଞା ଚାର୍ଜ ସିଟ୍ ହେଇଗଲାଣି।
File an affidavit. When comes for the petitioner, takes 1 week time to file an affidavit regarding the detailing the antecedents and the particulars of all the cases and their status. At least after 1 week. Yes. File an affidavit.
May I please your lordship, Millard? 20 years young boy, Millard, love affairs, and the so-called victim also married to another Millard boy, Millard. After that, there was dispute arose. Then Millard, she returned back to her parents' house.
What is the victim says?
Victim said love affairs.
Victim age is not.
Victim 20 and more 22.
My lord, I'm sorry, I may be pardoned, my lord, because CD is not there, 3762 and my lord, victim is conceived, my lord. So CD is necessary value.
Call for CD. Call for
6th ରେ ଥିଲା Millard, ଆଜିକି ରଖିଥିଲେ।
After 2 weeks. Yes.
After 1 week after. Last time Millard 1 week after.
Yes. Yes. Next. Are you ready to marry? No.
Evidence okay, she married to another boy.
Okay, already married.
Married, and thereafter dispute arose between them. Then Miller she returned back to her parents' house and lodged affair. ମୁଁ ତାକୁ ଭଲ ପାଉଥିଲି ଫୋନରେ ଗପୁଥିଲି.
Why shall I issue notice if that is the case? I issue notice to
No.
you implead her.
Issue notice to the
informant. Because she is a measure. Already married. Right on. Land counsel for the petition case, right? Seeks to implead the victim. As opposite party number 2. Opposite party number 2 implead and issue notice. He may say so. Issue notice to opposite party number 2. Yes.
Notice ଟା ଯୋଉ
ଗୋଟେ ସପ୍ତାହ ପରକୁ ଡେଟ୍ ମିଲର ଦିଆଇବା.
Did you follow for you? Yes.
ଗୋଟେ ସପ୍ତାହ ପରକୁ ମିଲର ଡେଟ୍ for her appearance ମୁଁ ଦେବି.
You implead her right now and file the process so that
Right now ମୁଁ first title file କରିଦେବି ମିଲର upload କରିଦେବି ମିଲର.
paperless.
Paperless.
Paperless. You please do that. Yes. Next.
27.
27, my lord. Petitioner is my lord 27, and the present victim is also 27. They are having in a relationship. Dispute arose with regard to
Custody since?
My lord, the petitioner is inside custody since 8/3/2024.
I am for the informer.
164. Read.
My lord, 164 is available, but it is not legible copy with mine. If
You have.
friend has, he may.
You have 164.
If learned
Yes.
friend has, he may-
Read it out. You are opposing.
Madam, the money near about 3 lakhs has been taken by the petitioner. From time to time, I have given the bank.
For money, you have registered a rape case.
No. In fact, by showing my nude photograph, he had blackmailing me. That was the FIR. And time to time, he was telling.
You were in relationship.
But charge sheet has been submitted under section 373 only, my lord. No IT Act is there, my lord. In the charge sheet, there is no IT Act.
That's a big objection. File the objection after 1 week. File the objection.
Let him serve a copy on me.
Copy, sir. Serve the copy to.
My lord, just now I will serve.
Bigger than your petition.
Yes.
Objection is bigger than your petition.
Objection should be bigger than the petition.
Yes. Next. Well, out of the way.
Well, 1 week after, my lord.
No, 1 week.
164.
And in this case, the present petitioner was implicated on the basis of co-accused statement.
Yes.
Initially 379, then down to 407 and 120B. And in the meantime, one co-accused was got anticipatory bail, was on a similar footing, my lord.
A habitual offenders, my lord. This petitioner has 11
one co-accused-
criminal antecedent, my lord.
How many?
11 case criminal
Co-accused, my
antecedent.
lord, co-accused
And
of
his
this-
co-accused, my lord, 26 criminal antecedent.
He was
And he
arrested.
get, my lord,
He was granted anticipatory bail.
Stolen AC coils not yet been recovered.
Yes,
my lord.
yes, yes.
Investigation
Charge sheet
is open,
submitted.
my lord.
Charge sheet.
And who is the co-accused? Rajesh Kumar.
Co-accused, my lord, co-accused is
Who is 26 NTC?
26, my lord. Co-accused name is, my lord,
My-
his name is Toppo Purushottama Bhutia.
What about Rajesh Kumar, sir?
Rajesh-
He had antecedent.
Yeah, he has an antecedent for
You
which.
tell me how many antecedents.
Yes. He has an antecedent for which.
You tell me how many antecedents against this man who has got executed bail.
Rajesh
You
Kumar.
are seeking
Yes.
parity with him. So you must tell me. This order doesn't say anything.
For which there are cash security is in anticipatory
Okay,
bail.
security, I don't know.
For that.
You tell me.
5 to 10 antecedents are there.
Against him.
Yes.
File affidavit then. Then counsel for the petitioner seeks to file an affidavit enumerating the number of cases registered against him and the status of this case, and as well as the number of cases registered as well as disclosing the antecedent of the co-accused
Rajesh Kumar.
Saw, who has been enlarged on anticipatory bail. You file an. You
Well,
seek parity, then you must tell me that. After 2 weeks.
In the meantime, also some charge sheet material witness has been examined. I am in only custody, only my lord. And next date, next week, my lord.
Please give me next 30. 30.
This matter. One Saraswati Yamuna Malik has lodged FIR alleging that her daughter was missing. And subsequently,
My lord, may I pardon to mention, my lord, earlier your lordship has been passed a order 10/9/2024. Surendra Bhuya. That in this case, my lord, this Surendra Bhuya is the father of this petitioner, this purport. And Surendra Das was stood there and directed to his son, this Papun, to attack and finish the deceased. So, your lordship may kindly maybe continue. Papun Bhuya. Sorry. Continue. Sorry, my lord.
Made your job easy. Yes.
Initially, FIR was lodged by one Jamuna Malik, alleging that her daughter was missing. So 2 days after, the FIR was lodged under section 363. Subsequently, the victim went to the
over.
investigation.
Charge
is
sheet
over.
filed when?
Charge sheet filed on
11/6/2024 has been charge sheet filed, my lord.
Charge sheet 11/6/2024.
13
Now, under? Which
Under 363, 376, 3 and 42 of POCSO Act. Your lordship, I have filed.
13 years minor girl.
And this boy?
This boy is 22 years old. 22, 20.
One
Your lordship, medical report is silent. If your lordship allow me, I can read the medical.
They were in relationship.
No, my lord. If your lordship allow to me, I may read the 164 statement.
Medical report is silent.
Charge sheet, I am finding that there is no charge sheet not submitted against the petitioner, but petitioner is inside custody, my lord.
Anyway, let it come.
My date may be fixed, my lord.
Charge sheet is submitted when?
Charge sheet submitted, my lord, in 26/2/2024.
Okay. It is, after that, the main application rejected. Okay. Yes, next.
49-year-old woman.
Huh?
49 years old, my lord, lady. She is in custody since 12/3/2024, having one son who is infirm. I mean, he is not. He is a polio patient. He is drug addicted person, much below commercial quantity. He is in custody. Charge sheet already submitted 12/3/2020.
Final PR has been submitted under no criminal entity.
No criminal entity.
Recovery how much?
Recover
187 grams brown sugar.
Brown sugar.
Brown sugar.
1 kg is the commercial quantity. No 37. So rigor of 37 will
170?
187.
187.
187 grams. 187 grams of brown sugar. 187 grams of brown sugar. Custody since 12/3/2024. 12/3/2024. The petitioner is a lady, a 49 years old lady having 2 sons.
One son.
One son. Regarding head to the
Physically handicapped.
Huh?
Physically handicapped.
Lady.
No, the son.
Having one son who is stated to be physically handicapped. Regarding head to the aforementioned, petition is granted bail subject to verification of antecedents.
May please your lordship. May please your
My
lordship.
lord, 306 before CD.
Your lordship, no 306, your lordship. Last occasion also, my lord.
My lord, I admitted to my learned friend. Already today's morning, I have been called to the concert office.
Yes, 1 week. 1 week CD.
Your lordship, no 306. It's a 40417 and 493 offense. My lord, your lordship, the petition is custody since 31/3/24. Last occasion it was listed since
item number. Item number.
Your lordship, item number 33. Your lordship.
Where is the charge sheet was filed? Charge sheet when charge sheet was filed. Charge sheet. So tell me the date of charge sheet.
Date of purchase.
When the charge sheet was filed? Huh? Charge sheet date, tell me.
Your lordship, 24/5/2024.
Then you go to trial court.
Your lordship, 417.
Agreed by
Your lordship.
16/5/2024, whereby his bail plea has been rejected. Subsequent therefore on 24/5/2024, the charge sheet has been filed. Since the bail plea has been rejected to the period of investigation and subsequently charge sheet has been filed, in changing was approved. The High Court by reading the certificate moved the same shall be considered on the basis of material forms part of charge sheet and within 15 days from such court. Yes, next.
Let me.
Yes.
34 to 34.
Sometime you are so unreasonable. I am saying CD to be called. To understand they don't understand the. Yes, 34. 34, yes. 30.
C4 similar to item 23.
20?
23, my lord.
Petition
That
will be hold
the
for
trial,
52 years.
trial is going on, 302 case. Trial is
23, what happened?
Your lordship directed to renew his prayer before the court. So all of
I can't have different.
From the 9, at the time of.
Whatever, because I have passed one order, then same order, 23, same order, 34. Yes.
36.
Maybe. 20 years boy.
25, 23, 30?
35.
36, yes.
35 Arjun.
20 years boy, 17 years girl. And madam, kindly have a glance to page 9. That is the statement of the girl. Both were having love relationship. It was opposed by the family member, for which the girl persuaded the petitioner to leave. Both of them went by motorcycle.
But if you see your what you call the cause title of a petition, everything is handwritten. Are you sure that he is 20?
My lord, 30.
Name, handwriting,
No.
father's name, age, everything.
36 CD is required. Some of the CD is not there.
Madam, see page 10. Madam, see page 10.
Yes.
Statement. Madam, see page 10.
Yes.
Madam.
164, what is 164?
161, that is there.
Do you have?
Madam, page 9.
9?
Page 9, my lord.
161.
Wow.
161. 164 you have.
164.
Next week, huh? Next week. Call for CD. Don't delay because the boy is 20 year old.
Yes, my lord.
If they are in relationship, I have been telling you, there is a difference between exploitation
Yes.
and
Obviously.
and these children don't know. These are not exploitation.
Only 3 documents is required. Medical exams report 161, 164. That can be obtained by the WhatsApp. Though we are receiving file at the late night 11.
I know.
So it is
You
not
have this, but see this you have distributes and wherever there is this kind of situation.
Yes,
is
yes,
there.
ma'am.
Young age difference you just see if they are in relationship. These two things you see and tell me so that I'll grant the bail without wasting.
Yes, yes.
And if age difference is much, and this a person
Obviously.
who is already married exploiting the child, you
That is
simply tell me I'll reject it.
Right.
These are the parameters we have to fix. If there is exploitation, no question of granting bail. Yes. Next week. Next week, make it.
My lord, I will obtain. Today,
Yes.
May I please, Lord?
37.
Yes.
37 also same, my lord.
What?
That CD is not available.
Sorry, Master, file is
Not available. Offense.
My Lord, 364 and 307.
Yes. Custody.
Custody since 8/3/24. My Lord, the allegation is the father of the informant has borrowed some money.
No. Injury, you tell me.
No injury. Because during kidnap, my Lord, on the midway, this petitioner left the victim as well as other accused person and went to his house. This is the allegation against this petitioner. And the person who was kidnapped, while the other accused person were taking alcohol inside the vehicle, he managed to escape from the spot. This is the certified copy of 161 of
My
the
lord, your
person.
lordship may kindly see page 14, ma'am.
40.
14.
14.
Para 4, ma'am.
Okay.
That the present petitioner, ma'am, para 4 to.
Yes, he has 3 to 4
One
antecedents.
is relating to 302.
3 to 4 and in all cases he is on bail.
You file affidavit. Land counsel for the petitioner. May file a affidavit detailing the antecedent of the present petitioner, status of the all the cases within a week, list up to 1 week.
Next week, my Lord. I will file tomorrow.
Leave this week, coming week, next week. Yes.
38.
Yes.
CDB call for.
CD. Yes. In the meantime, CD may be called.
Your man, the petition is in custody.
since
21/1/2024. Yes.
21/1/2024, my lord. The alleged offence under section 304B, 498.
Custody, sir, custody.
First one 21/24.
21/24.
20.
Oh, sir. 24. Okay.
01/24.
Okay.
After 2 years, he was arrested. After 2 years of incident, he was arrested.
Absconding.
Not
At the time,
absconding,
he was
not
absconded.
absconding, my lord.
And
Lordship may kindly see the affair. Affair is, my lord, that lady was married to someone, my lord, and having 2 children, man. And she, that her daughter was, my lord, was married, and thereafter, my lord, she want to live at Bhubaneswar, my lord. Then at Bhubaneswar, she was staying. The petitioner was, it is alleged that petitioner was also staying with him, my lord. Subsequently, the petitioner is not giving the house rent and also not come to that house. And subsequently, she died. And I have been entangled in this case, my lord, on circumstantial evidence. As because I was stayed sometimes and I have not paid the house rent, for that reason, my lord, I am in custody. Police.
How she died?
Due to strangulation.
Strangulation.
Due to strangulation. This was the second wife. And due to opposed by the family members, they were staying at Bhubaneswar.
Second wife, first marriage deserve it. There is no allegation.
But they were staying together.
Staying together.
They had
Marriage,
no, 498 may not.
304
30, I am concentrating on 302. 498 I am granting bail. Okay.
498 304 be over. But 302, what is the material against me?
What are the material? That's
Actually,
what.
there is no such material because no one has seen that they were last in theory is not there. Only on suspicion he was arrested, and on conviction he was implemented. Because those strangulation is PM report is
That's
strangulation.
right, but his confession cannot be read against him.
No, ma'am.
At this stage.
Yes, ma'am.
And what else you have collected?
My lord, there is no any other evidence.
Any other
that
then,
which
then he will be executed.
he is entitled.
Why should he be in the jail then?
Because my lord, on suspicion he was only arrested as a husband. There is no any other materials.
But
Even no one has seen that he was last in theory is not there, my lord.
Nothing is there, my lord. As because he
And
was,
when
But then what is the investigation you have?
investigation is, my lord, because he has not paid the house rent. So he some suspects that he might have marked guilty.
the house owner stated that when he opened the door, at that time he saw that the deceased was laying on the floor. And he suspecting that
Since how many month or days he was away?
my lord,
He was staying with that lady who has died.
my lord,
Okay. Since how many months he was not there?
my lord, I'm giving.
Rent, how many months rent you have not paid?
I'm giving it, my lord.
Yes.
The son of the deceased, my lord. Mo ma,
She was also divorcee.
Not divorced, my lord. She was
He
not.
was staying with the present petitioner because
Son
left
is not stayed
the
with that
son.
this petition.
And first is wife of the present petitioner also died. He was the second wife. Deceased was a divorcee. His petitioner wife was the first.
He may be involved, but the fact remains that you don't have evidence.
My lord, I'm only that reading some.
Yes.
ମୋ ମା ସମରେନ୍ଦ୍ର ବିଶ୍ୱାଳ ମଧ୍ୟରେ ପ୍ରେମ ସମ୍ପର୍କ ଅତୁଟ ରହିଥିଲା। ସମରେନ୍ଦ୍ର ମାକୁ ମାସକୁ 5,000 ଟଙ୍କାରେ ଭୁବନେଶ୍ୱର ସ୍ଥିତ ଓଲ୍ଡ ଟାଉନରେ କୈଳାସ ଚନ୍ଦ୍ର ମହାପାତ୍ରଙ୍କ ଘରେ ଭଡ଼ା ନେଇ ରଖିଲା। ସେମାନେ ସେଟା ଏକାଠି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭାବେ ରହୁଥିଲେ। ଦୀର୍ଘ 2 ବର୍ଷର ରହଣି ଭିତରେ 2 years 6 ମାସ ହେବ ସମରେନ୍ଦ୍ର ବିଶ୍ୱାଳ ମୋ ମାଙ୍କ ପାଖକୁ ଆସୁନଥିଲେ କି ଘର ଭଡ଼ା ଦେଉନଥିଲେ।
Son of the deceased is the informant in the present case. He, in his statement under section 161 CRPC, stated that his mother was in relationship with the present petitioner. They were staying together for about 2 years. However, since last 6 months preceding the crime, the petitioner was not coming to the deceased and was also not paying the rent of the house. The dead body was of his mother was discovered by the landlord. Out of suspect the several petitioners has been implicated in this dispute, in the case. Except, the confessional statement of the present petitioner, there is no other evidence which is coming on, which has come on record as yet. Charge sheet has already been filed. The petitioner is in custody since 48 except the confessional statement, nothing else. Even to the extent that no witnesses have come forward to stating
The last scene also.
stating the petitioner to be seen lastly with the deceased. On the contrary, the son of the deceased stated that since last 6 months, the petitioner was not coming to his mother, coming to his father. And petitioner is in custody regarding to the aforementioned regarding the nature of retribution and the weak evidence collected by the police during investigation and the period of custody and planned.
So the house owner statement also, they have not annexed in the case diary. He may be a.
Yes.
39. 39 member 302 CD requirement.
CD call.
For Chari Masalani CD.
No, sir, last time.
Last
27/5/2000.
Last and final opportunity is granted to obtain CD. It is made clear that no further adjournment shall be given on this pretext. Lease the matter after 1 week. Yes.
25. 25.
40.
I'm also supplying a Xerox copy of all the.
Please give so that on that basis you can assist.
This is also another case of 302.
Hmm.
Allegation is against the petitioner that
CD has come.
So CD is not there. He has annexed the
have
some
annexed
witnesses were examined, my right?
By now, Milord.
No,
I am
CD has to come because the coordinate
Is it
bench has
for the-
directed.
Right.
Coordinate bench has directed to.
From Bhadrach, my lord, your CD will come. Sort that.
So by the order dated 30th May 2024, the coordinate bench had directed the state to obtain the case diary, including the postmortem report. However, the counsel for the date submit that we have not yet received the CD. By way of last opportunity, leave the matters on such.
41.
41, let's see, 41 and 43 item, may kindly be permitted to withdraw.
41, 43, withdraw?
Yes, and 42.
41 and 43.
No, 41 and 43.
42.
42, my lord. The petitioner is in custody, my lord, since 10th of April 2024, my lord. 10th April 2024.
Okay.
Offense under section 457, 380, 411 and 413 of IPC. My lord. The petitioner is a goldsmith having a registered owner in the name and style of MS Sriram Gold Machine Testing and Laboratory. The petitioner has been implicated.
Wrong. For us, my senior has stated wrong custody. Custody date actually 24/3/24.
24/3.
It was reflected in the rejection order.
24/3/24.
24/3/24.
Yes.
And offense is charged was submitted under section 457, 380, 411, 430. And 44 numbers of gold ornament was seized from the present petitioner and 4 numbers of antecedent is there.
My lord, previously the petitioner has no antecedents. Once he has been arrested in one case and remanded in other cases.
In this case, you were arrested?
Remanded. In this case, remanded. I have been remanded.
In which case we were arrested first?
Arrested, my lord, Bargod PS case number, my lord.
What are the recovery in the other case?
Recovery, my lord, and my
It
lord,
appears you are habitual.
no, no.
So much of gold recover from you.
Most
Those who are stolen the property, they were sold the present petition. He was involved with
Yes, to go.
and 411.
411.
My lord, prior to this, I
He
don't have.
he has employed many people to
For that reason, my
collect
lord,
things and
for that reason, 44 numbers of ornament was seized from him.
44 ornament.
Gold ornament आएगा मो दुकानी मु सुना दुकानी आएगा
My lord, he
सुना
suppose,
दुकानी जहाँ
सुना
तला
दुकानी
सब
बाहर लोगों को चुराई सुना दुकान पकड़ते हैं
नहीं sir.
That is the allegation.
my lord, suppose assuming that he is the owner of that shop. But assuming that he is the owner of that shop. When the owner will only keep 44 numbers of ornaments.
Only.
Petitioner is
So realize our jewelry shop so much of gold he accumulated.
My lord, the petitioner is implicated on the confessional statement of one co-accused Parsuram Giri.
You file an affidavit, file an affidavit detailing your antecedent and in which case you were taken into custody and subsequently remanded.
Just pass over, I will verify the record.
No, you file an affidavit, I will put it next week. Let counsel for the petition to file an affidavit detailing the,
Lordship,
detailing the antecedent and disclosing
day after tomorrow, your lordship.
in which case he was taken into custody and subsequently remanded in the present matter. Release the matter after 1 week, yes. It should come on record so that I can reproduce and.
No, I have the documents with me. The
File
lordship
affidavit.
will pass over, then I will file on by to.
You want a rejection right now? Then I'll relegate you.
In all cases,
You do one thing. You go to trial court and repeat your.
my lord, in all cases, he has been granted bail.
So give an affidavit. I will have to.
Yes, my lord.
Make part of it.
Yes, obliged.
You want rejection? I can do it.
No.
Yes. Next.
44.
44.
May I please, lordship? Here the offences are under section 392, read with section 25(1) of A of the Arms Act, Miller, and the petitioner is in custody since 16/1/2024.
16/1/2024. 24. Okay.
Charge sheet has already been submitted, and the petitioner was taken into remand. Initially, he was arrested in another case, and he was taken into remand on 19/1/2024. On the last occasion, your lordship was pleased to direct me.
What is this affidavit which you filed?
Yes, my lord.
Manjula
Manjula Behera, the mother of the petitioner, filed this affidavit with regard to antecedents of the present petitioner, my lord. The present petitioner has got 4 antecedents, out of which he has been released by the Law and Trial Court in one
Two
case.
cases are pending.
Millards. And in another
two cases you got bail and 2 cases are pending.
Yes, my lord. And in other cases, in the meantime, the Honorable High Court has already been directed to release him on bail.
Yes.
With some condition, it may be allowed because
you are in custody since
16/1/2024.
What are the allegations? He has not filed anything. That's the problem. Except rejection order, there is nothing.
392, 25.
392 and 25 of the answer.
I don't know what are the offenses are.
Yes, in the rejection order, it has been rejected.
Difficulty is on this ground. I should reject it basically. No FIR copy, no charge sheet, nothing except the rejection order. The rejection order is sketchy. What is the FIR? What are the offenses? I'll suppose give this kind of dictation. These people are struggling hard.
Yes, ma'am.
To get what is the FIR number? Nothing is there. It is easy for you people to say do it. And these people will keep on struggling to find out what is the FIR number. Nothing is there. File the FIR. Where is, so give me the FIR. And why are you keeping it for you? Why are you not filing it in the court?
Initially, at the time of getting the brief, it was not with me, and subsequently I got the.
I think I should pass the judicial order.
No,
yes, ma'am. It
no,
is required
no,
because
no,
all
Miller,
document he has to
because
file. And the rejection
with a
order,
bona fide impression, in the
rejection order was charge sheet was submitted after rejection order. He will let it in his prayer before the court.
No, my lord. Charge sheet was submitted since.
No.
25/5/24.
Yes, ma'am.
Learn things how to be done. High Court को आप कचहरी से नीचे कर दिए.
As in the
कचहरी भी ऐसे नहीं होता है.
As in the rejection order, it has been mentioned. So
when charge sheet was filed?
25/5/24.
25?
5.
Right on. Petitioner is agreed by the order dated 21/5/24, whereby his bail plea has been rejected. It appears that during the investigation, the bail plea has been rejected. Subsequent thereto, on 25/5/2024, charge sheet has been filed. In view of the aforementioned changing circumstances, petitioner is granted liberty to renew the bail plea before the trial court. Before the trial court, if such bail plea is moved, the same shall be considered within 15 days on the basis of the materials which are form part of the charge. Yes,
No, my lord, let I be released on bail.
And you learn to file proper petitions.
19-year-old boy,
Yes.
I have
Next,
no
next,
criminal
next,
antecedent,
next,
nothing,
next.
nothing else. My lord, I am in
45.
custody since more than 7 months. My lord, I am
45.
I am prosecuting
45,
my
my
study,
lord.
study in +2 college, my lord.
Yes.
Yes, my lord. My petitioner is in custody since 29th
I'll
April.
hence fourth I'll reject all the petitions. Then the message should go. This petition is also to be rejected. Just see rejection order, nothing. Everything is oral. Whatever you say, I have to accept, and on that basis, I'll pass a direction. And tomorrow, if somebody challenges somewhere, on the record, there is nothing. There is
Arising out of excise matter. So that's why, my lord,
there is nothing, no complaint, no
Yeah.
FIR, nothing is there.
yes,
You have been
the
arrested.
PR report. PR report is there on PR.
Where is that?
Okay.
Where is that?
Yeah,
Let it file all the documents, my lord. It will be systematically, if they will not.
Otherwise, see, otherwise these people will not learn. Some young people are there because we are encouraging. Why to
And your lordship is
create
correct.
problem for them? We are encouraging. That is the reason. Very casually, one-page petition without anything. Even FIR number is not there sometimes.
And your lordship is correct. Suppose this order is challenged before.
Challenge
If
somebody.
there is no
Somebody
documents before
challenges.
the.
Take certificate copy. What will happen? What the high courts are doing? This will be the comment. Usually practice, leave it. This is minimum. At least the court is entitled to know what is the FIR number. You withdraw and file it. Learn counsel for the petition.
My lord,
Withdraw this petition
I will
to
file, my lord, next.
File a fresh petition with all relevant documents.
Next week
With
on
this liberty, the petition is.
next week on any date I will file,
No,
my lord.
no. You are young people. Why should you do that?
I apologize for
No,
my mistake, my
because
lord.
you have been encouraged by this court.
My lord, this is my mistake, my lord. I have not
So,
filed
for
a PR
that
report.
mistake, for that mistake, you have to be penalized. So file a fresh petition.
It
Fresh
will
petition.
take
Next
time,
46.
my lord. So that's why.
All the petition I'll dismiss today. I'll tell you.
46.
Very irritating.
My lord, on next week on any date, my lord, at least one chance be given to me, my lord. At least this is the last chance.
Be sit after 2 weeks. Then consequently, petitioner seeks an adjournment on the ground that he would be filing relevant documents to substantiate his case. Least the matter after 2 weeks. And 2 weeks your client is remaining in custody
Yes,
because of your mistake. This what service you are giving, you just demand. Don't do it. See, High Court means High Court level of the High Court has to be maintained. Minimum pleading, minimum document has to be filed. Many a time what happens, we don't call for the CD. And the proceeding you will see the CD is not called for. Nothing is there on record, but bail is granted. What will be the implication? So it's so very dangerous. Don't convert this court to like this. Yes.
46, may I please, my lord?
Yes.
My lords, I am incarcerating since 15/4/2024, my lord.
Yes.
My lord, dates are important in this case, my lord. The age of the victim, my lord, date of birth is
376-2.
376-2N and 6 of POCSO, my lord. My lord, date of birth of the victim as well as the informant is, my lord,
2004.
2000. No, my lord. Informant is 5/5/2005. And my lord, my age is on 19/3/2004. My lord, date of FIR is.
Now, what is this certificate? This is Vasudev Behra.
My lord, that is the accused, my lord.
Accused. That is.
Accused.
Then you are about.
Victim, my lord, date of birth.
My lord,
5/5/25.
Victim.
Victim 5/5/2005. And
one year difference, basically. 1 year.
And my lord, here what happened? The rejection order was passed on 21/5/24. Charge sheet was submitted on 11/6/24. And in the meantime, my lord, on 6th August, the victim was examined. Let it renew his.
What she said?
She has supported.
Supported the prosecution.
My lord, this is a case, my lord, if my lord may permit me.
Oh, they were in relationship.
They were in relationship, my
You
lord.
are in relationship.
My lord,
Read that part, read that part.
My lord,
Evidence.
my lord, I'm giving the certificate.
You will be convicted, but
My lord.
that's the problem.
My lord, this is a case
My
where
lord,
my lord 6 of POCSO Act has
I
been
understand.
registered, but my lord, I have not been given a benefit of the juvenile justice protection, my lord, because at the time of occurrence, which she narrates that it was in the year 2021.
That time you
That
were-
time I was minor, she was also minor, my lord. And at the time of FIR registration, I was also major, she was also major. The case was registered under, and
that is the
I'm giving the
deposition copy.
certificate copy, my lord.
Deposition copy. That
Deposition
she has
copy, your
taken the
lordship may
photo.
just. Yep. And my lord, with the effect of that photographs, my lord, that has not been recovered from the present
These
petition.
things are very, see the trauma of this girl.
My lord, your lordship may just.
You read it.
My lord, I have read that.
Will you argue it?
Lordship may just observe that the
See,
age
the
of
girl
the.
is girl is operated. She was suffering from a tumor in the breast.
That was
And
the
he
allegation.
forced her to show that
That has not
in
been.
the hospital. And you took the photograph and exploiting that photograph. See, this is perverse.
My lord, I bow down to whatever my
And
lord says, observing my lord. My lord.
Petitioner is agreed by the order dated 21/5/2024, whereby his bail plea has been rejected. Subsequent thereto, the charge sheet has been filed and the victim has also been examined in the court on 6th August 2024. In view of the aforementioned development, the petitioner is granted liberty to renew the bail plea before the trial court, and the trial court shall decide the bail application on the basis of the materials available on record. With this liberty, the petitioner is. This is the girl is.
My
very
lord,
well.
just one point, if my lords may visualize. My lord, the occurrence was in the year 2000.
You take all the plea there. I'm not, since I'm not inclined, I'm relegating you.
Okay.
Take all the plea.
Let's see.
I just come.
So allegation is
CD
that
is there, CD.
CD is available, man. But when the rejection order was made, at that time 302 was not there.
No,
Subsequently, charge sheet was submitted on 10/6/24. 302 and other alleged offenses.
other offences have
Let
been
him
added.
report the court below whether 302 is added. So
It is added now.
because
Lordship,
dying
302
declaration is
agreed.
there, eyewitness are there, all things are there. Everything is there. But though 302 is added, so let him move before the court.
302
Renew your bill.
And born
When
injury.
the charge sheet was filed?
Charge sheet was submitted on 10/6/24.
10/6/24. Right.
Right.
Petitioner
Is
is agreed by the order dated 8/4/2024, whereby his bail plea has been rejected by the court below. Subsequent thereto, charge sheet has been filed on 10/6/2024. In the changing circumstances, the petitioner seeks to withdraw this petition to renew his bail plea before the trial court. If such bail plea is moved, the same shall be decided on the basis of the material form part of the charge sheet. With this liberty, the petitioner is disposed of. Yes, next.
48.
मतलब 48 prefer one week after मतलब 48 मतलब
Yes, what do you want?
prefer 1 week after मतलब
Okay, adjourn on the request of the learned counsel for the petitioner, adjourn to December.
Okay.
December 14.
My lord, on behalf of Memar Das, may kindly permitted to withdraw the
Withdraw. Oh, okay. Withdraw. Yes.
obliged, my lord.
51.
Withdraw. 51 also. 51 withdraw.
52.
May I please? My lord, here charge sheet was submitted under section 363, 373, 63, 294, 363, 376, 2F and 6 POCSO Act, my lord. Kindly have a glance to the, my lord, running page 46. The statement recorded during trial of the informant's mother, my lord. The informant's mother, my lord.
Yes.
That running page 46.
Yes.
My lord, Mamata, so name hala Mamata Muduli. Informant is my daughter. Accused Balaram Muduli is my own Bhanaja. The victim was loving one man, namely Sunil Ghade, to which we did not agree. So the victim has filed this false case against the accused, as because he was not supporting her. Since last 6 months, after filing of the false case, the victim has left the house without telling anything to us, my lord. Since then, the victim has absconded and I do not know her present whereabouts, my lord. Cross-examination, my lord. The victim has filed this false case. I have received summons of the victim sent by the court by register post 3 times, but she
Yes.
has absconded.
Yes. She is the mother of the victim.
Yes, my lord. My lord, here is the case, my lord, where the minor girl was love affairs with one my lord Sunil Ghade. He is of lower caste, my lord. And while the mother of the victim and the present petitioner, he is, my lord, one of the brother, my lord. Opposed her relationship, this false affair has been lost.
What is the FIR?
My lord, kindly have a glance. Running page 11 is the affair, my lord.
Huh?
Running page 11.
What are the allegations against you made by?
My lord,
this
I'm
girl?
placing the FIR, my lord. ମୁଁ 1 ବର୍ଷ ହେଲା ଗୋଟେ ପୁଅକୁ ଭଲ ପାଏ ଯାହାର ନାମ ସୁମିତ କୁମାର ଗଡେଇ ବାପପୁର। ଏହି ବାବଦରେ ମୋ ମା ମମତା ମୁଦୁଲି ଓ ମୋର ପିଉସୀ ପୁଅ ଭାଇ ଜାଣି ଦେଇଥିଲେ। ଜାଣିବା ପରଠାରୁ ମୋ ଭାଇ ବଳରାମ ମୁଦୁଲି ଓ ମୋର ସେଇ ମା ସେଇ ଦିନ ଠାରୁ ମତେ ବିଭିନ୍ନ ପ୍ରକାର କଥା କହି ଡରାଇ ଚାଲୁଥିଲେ। ମତେ କହୁଥିଲେ ତୁ ଛୋଟ ଜାତିରେ ଭଲ ପାଉଛୁ, ତତେ କହି ଘରେ ରଖେଇ କି ଗାଁରେ ପୁରାଇ ଦେବେନି। Thereafter, my lord, allegations are there, my lord.
What are the allegations? That's what I want to know.
ଏଥିପାଇଁ ମୋ ମା ଓ ଭାଇ ମିଶିକି ମୋ ଦେହରେ ଏକ ଔଷଧ ପାଣି ଆଣି ଲଗେଇଲେ, ଯାହାକି ମୋ ଭାଇ
Miku, Praveen Kumar.
Say informant statement which he has deposed. I have annexed the depositions, my lord. Page 17 kindly have glance, my lord.
Already recorded, huh?
Yes, my lord.
Yes.
The prosecution case, I am sorry, in short, I am giving. The deceased, my lord, was a
Read the evidence.
Yes, my lord.
PW1.
PW1. I am the informant in this case. The accused present inside the dock is my nephew in my village relation. The deceased Suresh Bhue was my elder brother. In the morning of 11th September 2022, one of my co-villagers, namely Mohana, who has died in the meantime, came to me and informed that my brother dead body is laying at the middle of the village. The dead body was covered with a stone bamboo.
Forget it. Next program. I and my family members.
I did not notice any visible injury over the body of my brother, but he was dead. And the relevant is, my lord, next page, page 18.
Yes.
Paragraph 3. It is a fact that he, my lord, turned hostile. And it is a fact that 15 days prior to the occurrence, my deceased brother had quarreled with Miku Patnaik. Some person said so, that prior to this dead body was found, there was a quarrel with the present petitioner.
Yes, what else? Evidence.
The files are related to Mr. Patro.
Okay, next, he is not prepared. Next week, huh? Next week, yes.
55. Next week, my lord.
55.
Next week, my lord.
Yes, 55.
May I please, lord?
Yes.
Petition is judge custody lordship, 1st December 2023 lordship.
1st December
2023 lordship.
Okay.
Alleged offense lordship 302-201.
Yes.
120B 376D lordship.
Chandramani Bhoi.
Chandramani Bhoi lordship,
Yes.
present petitioner. Initially,
brother of the deceased lodged this report, Lordship. Paraswara Bhoi, he the
So what
informer.
are the allegations? Come to the point.
Lordship, the informant is accused in this case, Lordship. The informant, the brother is accused in this case, Lordship. Basing upon his statement before the police, I am there as accused in this
Yes,
case,
CD is
Lordship.
there. Mr. Rahul, CD is there. I've gone through. Go through. 302.
The brother is the main accused in this case.
Next week, yes.
Let's
Read it, huh? Next week.
Any short date.
56. 56 may I please, Lordship?
Yes.
Last time I'm short for the 164 treatment and medical examination.
Yes. Has it come? 64. 164 statement and medical examination. Naveen follow किया क्या? Yes. It's there.
Both are in log relationship.
Let us see 16. You were 28 years. Married? You were married?
No. When the informant got to know that actually
ମୋର ଝିଅକୁ ଧରି ଶୋଇଥିଲି ନବୀନ କହିକିଆ ମୁଁ ଘରକୁ ଆସି ମୋ ସହିତ ଜୋର ଜବରଦସ୍ତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲା ମୁଁ ତାକୁ ମନା କଲି।
However, taking into consideration the previous conduct of the victim and in the victim and the fact that the petitioner has already been enlarged on bail, in that case, I am inclined to allow the present petition. Regard being head to the acquisition and period of custody from 18 to 2024, the petition is enlarged on bail. Yes.
now this is committed and trial is 14 sessions.
14 sessions. Yes. Next.
57.
May I please, Lordship, my lord? Petitioner is custody 13 for 24, my lord.
13
for 24. Yes. They both in love and married, my lord. I have given the 164 statement.
They're married also?
Yes, yes. Mandir Bhai, she is stating so, my lord.
You have 164. Read it out.
Married, madam. ମୁଁ ଗତ 1 ବର୍ଷରୁ ସୁବ୍ରତ କୁମାର ଦୀପକୁ ଭଲ ପାଉଛି ଗତ 3-4-2024
You are also 18 years.
Yes. ସେ love ହେଇଗଲା I was
right now you are in custody since it
13 for 24.
What is the age of this girl?
17 plus.
Yes. Read it.
3-4 ପରେ एकटाରେ ମୁଁ ଆମ ଗାଁର ଛକକୁ ଗଲି ସେଇ ପିଲାଟା ସେଇଠି ଥିଲା 1-4-2024 ପରେ ଆମେ କଥା ହେଲୁ ଘର ଛାଡ଼ିକି ପଳେଇବା ବୋଲି 3-4-2000 କୁ ପଳେଇବା ବୋଲି ସ୍ଥିର କଲୁ ସେଇ ଦିନ ରାତିରେ ସେ ମୋତେ ବାଇକରେ ନେଇକି ଗଲା ଚିଚିଆ ଓ ସେଇଠୁ କେସିଙ୍ଗାରେ ଗାଡ଼ି ଧରିକି ରାୟପୁର ଗଲୁ ରାୟପୁରରେ 4-5 ଦିନ ରହିଲୁ ସେଠି ମନ୍ଦିରରେ ବାହା ହୋଇଗଲୁ
during the investigation the statement of the victim the girl who is stated to be what it is
मतलब 6 date of birth 23-27 almost 17 plus above 17
years has been recorded by the police. He in her statement has stated that she has been in relationship with the present petitioner who is also stated to be about 18 years of age. She on her free will had accompanied the petitioner to different places and subsequently in Raipur. They married, huh? Where is that?
yes. Mandir Raipur.
Raipur, and subsequently on 8/4/2024, they both of them got married in a temple. Got married on a temple. Got married in a temple. It appears that the family of the victim are not happy with the alliance, therefore the FIR was registered. Petitioner is in custody since 13/4/2024. regarding to the age of the victim as well as the present petitioner and the period of custody, nature of acquisition. I am inclined to enlarge the petition on bail accordingly. Oblige, please. Yes.
Your Lordship, this is
Yes.
case under section 20B second C of NDPS Act.
Yes.
And Your Honor, the quantity of seized ganja.
CD called. CD called for. Yes. Next.
Your Lordship, charge sheet has already been submitted.
I am calling for CD. Okay.
Yes.
Next.
Recently, my lord, 363 FIR was lost. Subsequently, my lord, after elopement and the victim girl was
376 3 lots.
376 3.
Notice.
Confirm.
Notice service.
Issued is
Service.
sufficient.
Service not complete. Notice. Yes. Notice issue. Issue notice. There is no notice in fact. Notice has not been issued. No issue notice to the. Have you implemented opposite party number 2 returnable within 2 weeks?
Yes.
Release the matter after 2 weeks. Meanwhile, CD of the case may be obtained by the state.
May I pray for shorter? May I
It will take 2 weeks in any case. File the requisite sender. Yes. 60.
May I please, my lord?
Yes.
My lord, the petitioner is in custody since 9th May 2024. And my
9
lord,
May
2024, my
Okay.
lord. Charge sheet submitted on section 420, 408, 467, 468.
Not with me.
When the charge is submitted?
On 4/9/2024.
Let me get the charge sheet.
Charge sheet ଆଉ କଣ ଆସିବ ସିଡି ଟା ତ ଅଛି charge sheet.
No problem.
4/9/24.
My lord.
Yes.
My lord, allegation is that the petitioner was working as an accountant since 2007 in the company office of Messrs. The Seal Coat Structural Works Private Limited, Bhubaneswar.
Yes.
And its aim and object for construction, repairing for bridges and so, my lord.
Yes.
As per the allegation of the FIR, I have enclosed the FIR, my lord. At page 17, my lord, may I have a
You
glance?
tell me
My lord.
charge sheet is filed, na?
My lord, my lord.
What are the allegations?
My
in the
lord,
charge sheet?
allegation is that the informant found who is the managing director, that's in for the financial year 2015-16, 2016-17 up to 2019, there is a misappropriation of huge amount from the company's account.
How
Company's account
How much?
that is 2 crores some amount, my lord.
You implead the informant. Implead the informant.
My lord.
Implead the informant and issue notice to the informant. Huh? But ideally speaking, you should go to the trial court because your application was turned down on 24/5/2024 and subsequent thereto charge sheet.
My lord, what is the problem in this case is there is no allegation as far as OPID Act is concerned, but the case has been transferred to the OPID court. That is the problem, my lord. There is no allegation on section 6 of the, it will
Then
not
to
come
argue
under
those things there in trial court. I am giving you liberty to argue.
My lord.
That's right. Petitioner is agreed by the order dated 24/5/2024, whereby his bail plea has been rejected. Then consequently, the petitioner submits that although
My lord, may I kindly
case under
observe one
OPID
thing more?
OPID Act is
My
made
lord.
out against the petitioner, still the matter is transferred to OPID court.
My lord.
It is seen from record that on 4/9/2024, charge sheet in the present case has been filed. Since in the changing circumstances, the petitioner seeks to withdraw the present petition to with the liberty to renew his bail plea before the trial court. If such bail plea is moved, the same shall be considered on the basis of the material formed part of the record shall be considered within 15 days on the basis of the material formed part of the charge sheet. With this liberty, the petition is disposed of.
That has also been observed by the law and court in the impugned order that since investigation is on progress, I am not inclined. That is also there.
That is, I have seen it out.
My lord.
Next.
61.
May I please, Your Lordship?
Yes.
Offense under section 20B2C NDPS Act, my lord. Recovery, my lord, 50 kg.
50 kg.
Charge
CD is there?
Yes, sir.
CD is called. Custody since?
Custody since, my lord, 24/3/24.
24/3/24. 50 kilos.
Only antecedent party is there?
Antecedent,
No, subject to antecedent.
verification of antecedent, recovery of ganja,
My lord.
contraband ganja 50 kilo, custody since 24/3/2024, granted, yes. Antecedent, yes.
May I please? The petitioners are in custody since 21st January 24, my lord.
Yes.
The allegation.
CD?
No, CD is not coming.
Huh?
CD is not coming. 302.
306. Call for CD.
And due to bathing in the pond, the quarrel took place.
CD, let the CD come. 302. Yes.
Omnibus, allegations are omnibus in nature.
CD, let the. Yes, next.
63.
CD?
Yes, CD.
Yes.
7 criminal antecedent.
Non-APS for the petitioner in the interest of justice, urgent.
64. May plus mail. Custody since 2nd May 2024. In meantime, charge sheet submitted on 1/7/2024. And the offense under section 376, 506 and 372F of the IPC. So, but the victim is a married lady, my lord.
Yes.
And she alleged the alleged rape against the petitioner, that the alleged incident was occurred on 3/4/2024 as per her, she lost the FIR. But the FIR was lost.
Charge sheet filed?
Yes, ma'am.
No, it's a charge sheet filed, yes.
She lost the FIR on 29.
What are the offenses in charge sheet?
376(1), 506 and 372F. So, but the 2F is concerned, where relation, she couldn't say, she is a married lady. As per her version, the alleged incident was occurred on 3/4/2024.
Married lady doesn't mean that you have a
No,
license.
no, that I am saying, my lord. So after, my lord, 26 days, my lord, the FIR was lost. And on 30th/4/2024, she went for medical examination. She denied for that. And after 42 days, again medical examination was conducted, nothing was found. And the medical examination report reveals that.
See, read 164.
And in the meantime, what happened?
164, read. 164.
Yes, sir. ବନମାଳୀ ବେହେରା ମୋ ସାଇ ଭାଇର ଦେଢ଼ଶୁର ହେବେ। ସେ ସବୁବେଳେ ମତେ କହେ ଯେ ମୁଁ ତତେ ଭଲ ପାଏ, ମୋ ସହ ସମ୍ପର୍କ ରଖିବାକୁ ଚେଷ୍ଟା କରେ, ମୁଁ ସବୁବେଳେ ମନା କରେ। ସେସବୁ କଥା ମୋ ବଡ଼ ମା ଦୋଇତା ବେହେରାଙ୍କୁ କହିବା ପରେ ସେ ତାକୁ ଗାଳି କରିବାରୁ ସେ କିଛି ଦିନ ଚୁପ୍ ରହିଲା। ଏହାପରେ ଗୋଟେ ଦିନ ମୁଁ ବ୍ୟାଙ୍କ କାମ ପାଇଁ ଗୋଟେ ଅଟୋରେ ଫୁଲବାଣୀ ଆସିଥିଲି, ସେ ମଧ୍ୟ ତା ଅଟୋ ମତେ ପିଛା କରୁଥିଲା। ଏହାପରେ ମୁଁ ଓହ୍ଲେଇ ଚାଲି ଚାଲି ଯିବା ସମୟରେ ସେ ମୋ ହାତ ଧରି ଟାଣି କରି ଅଟୋରେ ବସାଇବାକୁ ଚେଷ୍ଟା କରିଥିଲା। ମୁଁ ମୋବାଇଲରେ ମଧ୍ୟ ଛଡ଼େଇ ନେଇଥିଲା। ମୁଁ ସେଦିନ ମୋବାଇଲ ପାଇଁ ଅପେକ୍ଷା କରି ଘରକୁ ଫେରିଲି ଏବଂ ବଡ଼ ମାକୁ ସବୁ କଥା କହିଲି ଏବଂ ସେ କହିଲେ ଯେ ଯଦି କିଛି ନ କରିନି ବ୍ୟସ୍ତ କ'ଣ ପାଇଁ ହେଉଛି। ଏହାପରେ କିଛି ଦିନ ତଳେ ସେ ଲୋକ ଇନ୍ଦିରା ଆବାସ ମିଳିଥିବାରୁ ମୁଁ ଓ ମୋ ସ୍ୱାମୀ ମିଶି ତା ଘର କାମ କରୁଥିଲୁ। ସେ ସମୟରେ ମୋତେ ସେ ଖରାପ ନଜରରେ ଦେଖିଥିଲେ ମଧ୍ୟ ମୁଁ ଧ୍ୟାନ ଦିଏନି।
You have been consistently after her. Consistently.
3/4/24
Right on. Petitioner is agreed by the order dated 28/5/2024. Whereby his bail plea has been rejected. The subsequent thereto on 1/7/2024, the charge sheet has been filed. Since the bail plea of the petitioner was rejected during the investigation period and subsequently charge sheet has been filed, in the changing circumstances, petitioner seeks to withdraw the present petition to renew his bail plea before the trial court. If such bail plea is filed, the same shall be considered within 15 days on the basis of the material form part of the charge sheet. With this observation, the petition is disposed of. Next.
65, with pleasure.
Yes.
The petitioner is in custody since 29/4/2024.
20?
29/4/2024. Lordship, 25 kilos of contraband ganja was recovered from the
20?
25 kilos.
One antecedent similar in nature.
Antecedent.
One antecedent similar in nature.
Lordship, he has already been enlarged on bail.
Whatever. I will not say anything. Subject to verification of antecedents, grant 29/4/2024 custody and 25 kilograms.
Published, Lord.
6.
Pass over, Lordship.
No passover. Today, lot of matters, no pass.
One part. After launch, my lordship.
Release it after 1 week, huh? 1 week. Yes.
67.
24?
24/4/2024.
Yes.
Classical offense under section 372A, the 84, during post-production, they do to 60% of IPR. They did present the engineering student and completed the 22 years.
CD is there?
Yes, yes, it is there. Informant is 21 years. They are having a lot of regulations from.
POXO is there?
12.
12 POXO is there, madam.
It's not applicable because the allegation I am point. The allegation they have developed a relationship 2020. Allegation that after date of birth is 2004. After 2020, they have developed a relationship and they have kept physical relation after in the month of April 2022. By that time, you are 18 years. Thereafter, after 2 years, 31/3/2024. By
The allegation is they had the relationship in the month of April 2022. That time she was already measured.
At the time of occurrence, that victim reading at class +2, madam. That is there in the statement, madam.
Yes.
If it date of birth.
Read 164.
My-
This boy is also 22 years.
Yes.
Yes.
Read
Read 164.
At 164 is not legible, my lord. 161 is there. I'm reading the 164. I'm reading the 164, my lord.
161. We'll get
164 I'm reading it. 164.
Where
is that?
20 ମସିହା 2020 ମସିହା
Given by you, that is in the record.
Deposition.
It is mentioned.
Deposition. Okay.
Yes.
Deposition is there.
Same thing, yes, they have relation.
20 years.
In the house of the tenant. Frequently, they are never, frequently.
No, see, in her statement, she says, I'm 20 years of age.
Yes.
at the time of deposition, my lord, 2 years. But
20
occurrence took place while she was reading at +2.
18 years.
My lord?
18 years by the time.
18, yes.
My lord, 18 years.
What does she say?
Supported, not supported for the prosecution.
Not
my lord.
supported.
Well, not supported.
Other than what she will be acquitted, right? The petitioner is accused in such case. The allegation is the petitioner. Or the petitioner, the victim, the statement of the victim who is stated to be 20 years of age at the time of recording of the petition, in the 154, has stated that in the month of April 2022, the petitioner had forceful sexual relationship.
My lord, they supported, my lord, that. Victim supported in this case, my lord. Another case is like that, madam.
Vulnerable witness. No. He is not declared hostile.
Supported by
In camera.
and carried on
Vulnerable
investigation
witness.
in another case that is
Okay, deposition, receipt and identity diversity kept in the seal cover and evaluation of the victim. Yet in the year 2022,
Yes.
while I was studying close to. April 2022, they had released.
My lord.
Prior to that, he has taken that photograph.
But in the statement, in her statement, she stated that while she was reading at +2
That time.
at that time. But medical evidence, my lord, medical evidence report is there. And denied for medical examination. That is the
These, all, both of them are approximately the same age.
my lord.
Record the statement of the victim was recorded under 164. Subsequently, she also deposed before the court on 6/7/2024. She in a statement has deposition also. Deposition to A paragraph written. Para 2 in the year 2022. Year 2020. C paragraph. That paragraph. The letter counsel for the petitioner submits that in the year April 2022, when the alleged allegation was taken place, that time the victim girl was already attained majority. Moreover, the present petitioner is her classmate. Is the classmate of the victim, who is at present 22 years of age. During the alleged incident, he was about 20 years of age. 20 years age. The petitioner is a student. And who is in custody since 24/4/2024. Regard being head to the age of the victim and the petitioner, and the nature of acquisition and period of custody of the petitioner from 24/4/2024. Granted. Yes.
State may I please, Your Lords. Here, my lord, custody since 9/5/2024 and offences under section 394, 397, 307. I have annexed the injury report, my lord. Injuries are simple. Annexer 3. Your Lordship may kindly turn to page
Custody since
9/5/2024. No TI period, no, my lord, that recovery, and FR is unknown.
Charge sheet?
Charge sheet submitted, my lord.
Charge sheet submitted 26/6/24.
And here injury report, your lord.
26/6/24, my lord. Under section 397, 394, 307, 34.
Yes.
And section 25/27 Arms Act.
And injury report, your lordship, at page 13. It's simple.
And so
my
far
lord.
the TI period report is concerned, no TI period has been conducted in this case, my lord.
What is there then?
No TI period conducted.
What else is there?
My lord?
What else is there? It's injuries are simple.
Yes.
What is recovery?
No recovery, my lord. नहीं नांती किसी allegation भी नहीं, खाली मोबाइल टा मागिले से देलानी बोले बाड़ेली. ये allegation.
Yes. Do you have anything?
My lord, one page note instruction is there. Only instruction, one page note instruction is there. You are not challenged.
Shall I put it coming next week?
No.
Anytime?
Yes, my lord.
Next week.
My lord,
Next week.
Lordship.
Give it next week. I'll grant bail. I know that I'll have to grant bail, but wait, next week. The record has to be, kept straight.
A date may be fixed.
Yes, next week. Next week, good date. Don't delay it. Tuesday, Wednesday, anytime.
Item 69 I may be permitted, my lords. My lords, on the earlier occasion, my lords, case diary, up to date case diary was called for, my lords. And the petitioner is in.
Yes, my lord.
My lords, and the petitioner is in custody since 25/4/2024, my lords. The matter relates to an online fraud, my lords. And the total financial implication, my lords, is 25,93,200, my lords.
Yes.
So far as the financial implication in relation to the petitioner, as the prosecution has tried to establish, is 5,98,000, my lords. It is their case that during that fraud, my lords, in different stages, my lords, amounts were transferred to different accounts, my lords. And one such amount, my lords, 5,98,000 was transferred to an MTP Enterprises, my lords.
Charge sheet file.
My lords,
No, supplementary charge sheet file, man. Supplementary only supplementary charge sheet
When?
file.
my lord, that
14/5/2024, my lords.
the petitioner is a man of Rajasthan, my lord. And that
Aye.
26 to 28 complaints are pending against the petitioner all over India, my lord.
Yes.
However, in this case, is outside of the state to arrest the other accused persons, my lord. And during interrogation of the co-accused, my lord, that
It's a scam. He's involved in many cases across the country.
my lord,
He's involved in many cases
many
across
cases,
the
my
country.
lord. And that during interrogation of that co-accused, my lord, Amanullah Khan, it was learned that he was engaged by the accused Samimuddin Khan, my lord, petitioner, my lord, to collect various bank account numbers from Telegram groups and supply the same to him for siphoning fraud money collected from the victims. In this regard, screenshots of the WhatsApp conversation between Samimuddin Khan and Amanuddin Khan has already been seized from the court.
My lords,
Petitioner agreed by the order
one
dated
submission, my lord.
10/5/2012.
One
I am
submission.
not inclined.
My lord, the amount.
But I'll give liberty, you renew your bail plea. Petitioner is agreed by the order dated 10/5/2024, whereby his bail plea has been rejected. Subsequent thereto, on 14/5/2024, preliminary charge sheet has been filed. It is alleged that the petitioner is involved in many other cases across the country, and the co-accused persons are not yet been apprehended. Therefore, I am not inclined to enlarge the petitioner on bail. However, liberty is granted to the petitioner to renew the bail plea before the trial court on the changing circumstances that the charge sheet has been filed subsequent to the rejection of the bail plea. If such bail plea is moved, the same shall be considered on the basis of the material form part of the preliminary charge sheet. With this observation, the petition will be disposed of. Next.
My brother, my lords, my brother stated antecedent number, my lords, for my information kindly. My brother stated.
So are you always?
May I please, Lordship? And the present petition custody seals 31/1/24, my lord.
31/1/24. Yes.
The victim age is 17 years. And the present petitioner is 24 years.
Yes.
They are loved to each other. 164 statement as page 17, my lord, kindly have a glance.
17, okay.
17.
Read it out.
Annex 3, my lord. ମୁଁ ଆପଣଙ୍କ ଆଗରେ ଉପସ୍ଥିତ ରହି ସହ ବୟାନ ଦେଉଛି ମୁଁ ପଣ୍ଡିତ ଯୋଉ କଣ୍ଠେଶ୍ୱର ବିଶିକୁ ଭଲ ପାଉଥିଲି ସେ ଆମ ପଡା କଣ୍ଠେଶ୍ୱର ପ୍ରେଜେଣ୍ଟ ରିସନର ସେ ଆମ ପାଖ ପଡାରେ ରୁହେ ତା ଗତ 28/1/24 ଯିବି ତା ସହ ବୋଲି କହିଲି ତାକୁ ଅପେକ୍ଷା କରିଥିଲି ହେଲେ ସେ ମୋତେ ନେଲାନି ଘରେ ମୋର ଛାଡ଼ିଦେଲା 29/1/24 ପୁଣି ସକାଳେ ସେ ଫୋନ କଲା ମୁଁ ତା ସହ ଗଲି ଏବଂ ବସରେ ଭବାନୀପାଟଣା ଆସିଲୁ ମୁଁ ମୋ ସାଙ୍ଗ ନନ୍ଦିନୀ ଘରେ ରହିଲି ମୁଁ ତା ସହ ନିଜ ଇଚ୍ଛାରେ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲି ସେ କିନ୍ତୁ ବାହା ହେବା ପାଇଁ ମନା କଲା ସେଠି ମୁଁ ଗୋଟେ ଦିନ ରହିଲି ତା ପରଦିନ ଘରକୁ ପଳେଇ ଆଇଲି ତାପରେ ମୋ ସାଙ୍ଗ ମୋତେ
ନିଜ ଇଚ୍ଛାରେ ସମ୍ପର୍କ ରଖିଥିଲି.
Under
the time of
very young.
age of the victim 17 years, madam. Notice already served. Notice has already been served on dated 17/6/24.
Okay. No, she has not come. Notice was issued to the informant, informant and victim. Service of notice is complete, but nobody appears for them. Petitioner is an accused in FIR also, alleged with the petitioner also. During the investigation, the statement of the victim, who is stated to be 17 years.
Yes, madam.
17 years.
17 years.
Roughly about 17 years of age has been recorded. She, in her statement, stated that she has been in relationship with the present petitioner. On 29/1/2024 morning, on 28/1/2024, she was intending to go with the present petitioner. However, the present petitioner did not turn up. On the next day, on 29/1/2024, the present petitioner called the victim over phone, and both of them went to Bhavanipatna. She also stated that she stayed in her friend's house. Friend's house. The victim alleges that the petitioner promised to marry her and kept a physical relationship. Subsequently, the petitioner has wriggled out of his promises. Therefore, the present case is filed. The petitioner is about 24 years of age. He is in custody since 31/1/2024. Regard being had to the nature of acquisition and the period of custody, I'm inclined to enlarge the petitioner on bail accordingly. Yes. Okay, to Releva? Huh?
Pardon to make a mention, my lord. Item 94, both the husband and the informant and the accused is present, my lord.
I'll take it up.
My-
Yes.
Item 9.
9. Yes. When the charge sheet was filed? Rejection was? Nobody is appearing. That's the problem. 7/8/2023. Charge sheet filed on? Charge sheet filed on? Yes. Evidence recorded.
My lord.
Have you seen the file? List it tomorrow. Here.
Non-effect for the programs are there.
Non-appear for the petitioner in the interest of this list tomorrow. Clear. Call the password.
71.
Password only one. Yes. Settlement matter. Which one? Yes.
94.
90?
4, my lord. 94.
24. Yes.
4.
Yes. What is the offense?
498A, 323, 294, my lord.
Wife and husband?
My lord.
Family dispute?
My lord.
Yes.
My lord, my learned friend is appearing for the.
Ranjit.
I'm appearing for the wife.
Ranjit is appearing?
Done.
Jamesh for?
Ranjit.
Arundhati?
Anupama Milot is the wife and Ranjit Pradhan is the husband.
What about the other accused person?
Other accusation, my lord, father and mother-in-law of the present petitioner.
Why they are not present?
My lord, due to illness, madam.
Illness, how do I know illness? Whether they are alive or they are in custody, they are committing some crime somewhere right now?
My lord,
How do I know?
my lord, kindly listed on tomorrow.
This is very, I don't understand. You people are taking things so lightly. You want quashing of an FIR on the ground of settlement. Accused persons are not present. Legal sheet of Friday.
Apologize.
You might have advised, don't come, I'll handle it. Yes. 71. Yes. Bail? Yes.
Pradhan, my lord. Passover.
Passover, you go after lunch, what Passover?
Friday, my lord, kindly take it.
On the request, adjourned. 72.
In this case, my lord, initially, FIR was launched 376.
Yes. 70? 1 minute. 71. 71. Just time. Yes. 71. Yes. Yes, sir.
Custody censorship 29/6/2024 lordship.
Sorry?
29 March 2024 lordship.
Yes.
Offense charge sheet filed under section 498A, 304B and 34 IPC lordship.
Okay.
Allegation against the husband. And
You are the husband.
I am the husband lordship.
Yes.
And other two accused person already religion.
What is the allegation against? Neither 306 nor 302. 304B.
304B lordship. Suicidal.
Yes. Yes.
Immediately above that.
Huh. Poison. She has consumed herself or allegation of administrating the consumed poison.
Their statement that she has consumed.
What is that case?
Immediately we have admitted in hospital lordship. Immediately we have.
Now antecedent, what antecedent? Do you have any detail about it? File an affidavit regarding antecedent.
Lordship.
Then comes for the petition 6-1 with time to file an affidavit giving detail of antecedent of the petitioner. This is the matter of only case. Next. 72.
Next week, lordship.
Yes. Yes, 72.
This case, my lord, petitioner is in custody since 8/5/24, my lord.
Yes.
This case, almost all the evidence has been closed from the side of the prosecution. The present victim has also given her statement that we have already compromised the matter and now we have settled the disputes. And both victim as well as the petitioner will marry after release from the custody.
What is your age?
Age, my lord, 17 years, 9 months at the time of occurrence.
What is your age?
20, more than 20.
You have written 19 years.
But more than 20.
No, what is your exact age? You have written in the cost title 19 years.
No, because my friend was this is transfer brief. So far, my
You tell me what is exactly
20.
the age?
Exact age 20.
20 years.
Yes.
And a girl's age is?
Girl age is now more than 18 years. At the time of 17 years, 9 months.
17 years and
I have
19.
also
Yes, 164 read.
already statement I have already given.
Read that, read that. Yes. Hostile.
And that in cross examination defense are the question that my family members and the family members of the accused having good dogs. And I have heard from my mother that my date of birth is 31/7/25. I have nothing to say against the accused. This case has been filed at the time of instance of the doctor and the police.
What is the allegation?
Allegations, my lord, they are love affairs between the petitioner and the victim. And they were love details that thereafter they both have agreed for marriage. Subsequently, when she came to the medical for checkup, that doctor advised that
She is pregnant.
ultrasound is
Yes.
necessary for that.
Give me that evidence.
Evidence.
Give me.
My friend is also appeared for the.
What do you say, sir?
My lord, actually, I may kindly be permitted to submit the wakalatnama and the affidavit of the petitioner, of the victim. And both the parties, their families have already agreed for the compromise, and they have also.
Notice was issued.
No, she is not party because doctor is the informant. The present victim is not informant.
Then how can he file wakalatnama? For whom? You have not implemented it.
But just I have ready with the
Farin
my lord.
Who is Farin Almas?
Farin Almas is the
Victim.
victim.
I can't take your wakalatnama because not a party at all.
I'm filing the IA, my lord. I have also.
File IA for impleading.
IA.
IA allowed, implead, please it after. IA number IA for impleading the victim informant has been filed.
Already my evidence has been closed from the side of the prosecution. Only IO is there. IO has to be also.
Don't say that, then I will not allow you.
No.
Go there and the matter is at the fake end of the trial. Why should I enlarge you on bail?
Day after tomorrow.
Better that you see the IO cross examination is there. Then the trial will be over. Why do you want a bail then?
He is in custody more than.
Maybe, but what more than on May 2024? The trial is very satisfactorily going on. But I'll tell you within 2 months the trial should be concluded.
After tomorrow.
You tell me on that. Because at the fake end of the trial, why should bail be cancelled? Yes. Friday.
Statement clear.
Friday. Yes.
73. Day after tomorrow.
Friday. Monday. Let them file the application. You file the application first, Monday. Yes.
Friday, sir.
Monday. You have to file the application numbered and all these things.
Today it can be also numbered. Today
You get it done Monday. Yes.
23. Friday, how I will take my chance whether.
I'm telling you, Monday is better for you because it may not be numbered, then unnecessary it will be urgent.
Number
Okay, Friday. Yes.
On behalf of Sujakanti Bade, kindly taken up to this.
At the request of the land council, the petitioner, urgent the matter to December. Yes.
74.
Offense under section 21B of NDPS Act, my lord.
Yes.
Custody since, my lord, 16/2/2024 my lord.
16/2/2024. Yes.
Charge sheet has been submitted on 24/4/2024 my lord. Right answer to page number 14 my lord.
Yes.
No
Yes.
similar type.
What is the recovery?
174 gram brown sugar my lord.
Seven. 24.
Less than commercial quantity.
134, yes. Yes. What do you say? 174.
174 gram.
You have anything?
No similar type of case.
Verification. Right. If the charge sheet is filed, if charge sheet is all right, charge sheet he might have not got the copy from the police. That can be exempted, but at least a FIR copy. Yes.
Custody since 17/4/2024.
17/4/24.
420 along with other offences, my lord. Charge sheet submitted in the meantime 14/8/24. Allegation is that co-accused statement, I have been entangled in this case. Allegation is that page 10 your lordship.
Charge sheet for which offences?
Offense my lord 419, 420, 467 same FIR jaha se hai.
Okay.
Allegation is that one Sanjay Kumar Behra my lord made an agreement with the complainant to sold the land my lord, and money was transferred
5 lakhs.
No,
no,
madam. Total
41 lakhs 40,000 my lord. That was initially as per agreement. He has advance given my lord 5 lakhs. 1 lakh was transferred to my account, which was not gone. Thereafter, that was transferred to my brother's account. Thereafter, I got certified copy of the certified copy, and one man was engaged in presenting that the land was registered.
In whose name?
One the name of Sanjay
Kumar
Behra, who has taken the money, man.
And my lord, Sanjay Kumar Behra says that all the money has been transferred to him, my lord, and I'm appealing for the informant, my lord, in this case. And my lord,
What is the amount then? 6 lakhs.
my lord, no, my lord, total amount involved is 41 lakh
No, that is
40,000.
the agreement amount. But
No, my lord, that
paid
is the
5 lakh rupees cash, 1 lakh rupees transfer.
My lord, total paid amount is 41 lakhs 40,000, my lord. In the FIR itself, if my lord may peruse, it says, my lord, although it says, my lord, Sanjay
You
Kumar
have paid 41 lakhs
40,000, my lord.
In the
Through
form of what? Cash.
Cash as well as online
How much
transaction.
cash? One no. How much money?
My lord, it says, my lord, 41 lakhs for 40,000 was transacted from him through direct cash and by means of
You
online
tell me
transaction.
what is the cash component, what is the bank transaction?
My lord, so far as online transaction is concerned, my lord,
How much?
My lord,
You tell me, cash component how much?
my lord, so far as on perusal of the FIR, it
FIR total is the cash, my lord. 1 lakh was transferred by 5 lakhs. My more tharu.
15 lakhs, my lord, from the.
No, I am read out the FIR, my
Yes,
lord. 41,40,000 ଟଙ୍କାରେ କ୍ରୟ କରିବା ପାଇଁ ଚୁକ୍ତି ହୋଇଥିଲା। ଚୁକ୍ତି ମୁତାବକ ସେ 27/1/2023 ମୋ ଠାରୁ 5 ଲକ୍ଷ ଟଙ୍କା ଅଗ୍ରିମ ଗ୍ରହଣ କରିଥିଲେ। ଏହି ଦିନ ସଞ୍ଜୟ କୁମାର ବେହେରା ପୁଣି ଦଶଗରିଆ ନିବାସୀ ଶ୍ରୀକୃଷ୍ଣ ପିଟିସନର କୁ ଆକାଉଣ୍ଟ କୁ 1 ଲକ୍ଷ ଟଙ୍କା ପଠାଇବାକୁ ଅନୁରୋଧ କଲେ।
6 lakhs ହେଲା।
6 lakhs କିନ୍ତୁ ବୈଷୟିକ କାରଣରୁ ମୁଁ ଏଇଥିରେ ବିଫଳ ହେବାରୁ ସଞ୍ଜୟ କୁମାର ବେହେରାଙ୍କ ଅନୁରୋଧ କ୍ରମେ କୃଷ୍ଣଚନ୍ଦ୍ର ଚୌଧୁରୀଙ୍କ ଶାଳକ ରବୀନ୍ଦ୍ର କୁମାର ସାହୁଙ୍କ ଫୋନକୁ 1 ଲକ୍ଷ ଟଙ୍କା ପଠାଇଲି।
6-7 lakhs.
ନାଇଁ ସେଇଟା ଗଲାନି ଆଉ ଲକ୍ଷେ ଟଙ୍କାଟା ମୋ ଆକାଉଣ୍ଟ
7 lakhs. Even if it is gone, 7 lakhs.
My lord, after that, my lord, after that, if my lord, in turn, Sanjay Kumar Behra told that the entire cash received by him relating to the sale agreement was taken away by Krishna Chandra Chaudhary of Dasagaria and also produced his account statement in support of the same. As per the statement of Krishna Chandra Chaudhary had received a cash amount of rupees 15 lakhs on dated 14/2/2023, and his brother-in-law Rabindra Sahu had received a cash of rupees 5 lakhs on different dates from 27 January to 14 January 2023, my lord. And the rest cash were received by cash.
How much you have taken in tell me? 1 lakh. I've got, yeah. Then it makes
Police is not.
He has taken largest chunk of money, he is not arrested. He has taken less money.
My lord, he is yet to be arrested, my lord, and the rejection order was prior charge sheet, my lord. So, my lord.
Why don't you settle the dispute?
Hey, Locket, your lordship impose, I will pay it.
See,
My lord,
I'll give him interim
interim bail, my lord.
and send it to mediation.
Grateful, my lord.
I'm giving interim bail for 2 months, send it to mediation.
ପୁରା ବେଲ ଦେଇ ଦିଅନ୍ତୁ, ଲକ୍ଷେ ଟଙ୍କା ମୁଁ ଦେଇଦେବି ଆଜ୍ଞା।
No, no.
ସିଏ ଆଜ୍ଞା ଯଦି ନ ଫେରେଇବ ମୁଁ ପୁଣି ଭିତରକୁ ଯିବି।
He is your friend. Both of you have taken the money, right now.
No, that has not been mentioned in the charge sheet also, my lord.
You try. 2 months, thereafter we'll see. 2 months bail I'm giving. I'm sending it to mediation.
3 months देई दियंतु।
3 months, okay.
Yes,
3 months. You get whatever money you are recovering, get it. Because he is entitled to bail. You can't keep him for eternity. To recover the money.
Yes.
Have you filed specific performance suit? Go and file. Get your property. You can't see these are arms twisting method of collecting money. This is not permissible. I'm giving 3 months because see you may get some money.
Recording my
petitioner. Shall I take his undertaking that
yes,
3 months and grant him bail and send it to mediation also? Why to keep it pending?
Because my lord, after mediation,
mediation
and you, I'll give that liberty to move application for cancellation if it doesn't pay.
Yes.
At least one matter is disposed of.
Who has not been arrested.
Who has not yet been arrested. The petitioner is in custody since 17/4/2024. 17/4/2024. The dispute is basically regarding the payment being made by the informant to the petitioner on the pretext of selling a piece of land. The party, Mr. Mahapatra, I think for the opposite party informant.
Sale of land matter and impersonation.
That his grievance could be addressed if his money is being fully paid. Regarding it to the nature of allegation and the period of custody, I am inclined to enlarge the petition on bail with the condition that petitioner shall do well to see that the entire money received from the informant shall be returned as expeditiously as possible. In that regard, the petitioners are relegated to the High Court mediation cell to explore the possibility of a settlement, and the coordinator of mediation cell is directed to issue notice to both the parties fixing a particular date for exploration of the possibility. And the petitioners shall cooperate to investigation is over. Petitioners shall cooperate in the mediation process and mediation process. and with all other conditions, with the following condition.
And violation of
With
conditions.
that condition will be.
Yes.
Grateful, ma'am.
Obliged.
At least you mediate, you get some money.
Yes.
My lord.
Hello.
Grateful, my lord.
Yes.
Hello. Sorry, my lord. My friend has committed a mistake. Item 77. I am in VC.
Yes, yes.
My friend has committed a mistake. I have one time and cautioned him not to repeat this type of mistake. As a filed a memo for withdrawal of the case and instead of listing the case. If my lord shall permit, I will the place case. Otherwise, I have one and cautioned me, lord. During 30 years of practice, I will not.
Okay, will you file the FIR copy? I'll simply adjourn.
FIR copy filed. FIR copy filed.
No, not filed.
Yes, filed, my lord.
Yes, yes, you filed.
Yes,
Yes. Sorry, you filed.
only my lord shall ignore this withdrawal memo, then I will press because there is no option for me. On behalf of Mr. my friend Mr. Tinath Naik.
Yes. What are the allegation?
Allegation of 394 and 2527 of Arms Act, my lord. So far as the 394 offense is, my lord.
Charge sheet has been filed.
Charge sheet filed.
When?
So, my lord, arrest is 9/5/2024.
Huh?
Arrest charge sheet, my lord, June 30.
30th June.
Yes, my lord, 30th June 2024.
Yes.
I am in custody 9/5/2024.
9/5?
2024. 9th May.
Yes.
Only allegation of 394. 2527 act is not made out because as per the allegation, se bandukara pachpote tau garte pahara piti dechi.
Yes.
Bandukotare.
What are the allegation?
Allegation ho je mu setala loka asutila mu tatu batre jogili gote pahara piti dili tonka 1500 tadu chhadai neli.
4 antecedents are there, my lord.
Ah, you have antecedents.
Rejection of the
Antecedent, so far antecedent in one case has already acquitted, that is a family dispute, not this type of antecedents.
394 antecedents are there. Right.
394.
Petitioner is agreed by the order dated 27/5/2024. Thereby his bail plea has been filed. Subsequent thereto, on 30th June 2024, charge sheet has been filed. In the changing circumstances, the petitioner seeks to renew his bail plea before the trial court. Doesn't want to place this petition. If accordingly the petition is disposed of, with liberty to the petitioner to move fresh bail plea before the court below on the changing circumstances. If such bail application is moved, the same shall be considered on the basis of the material form part of the charge sheet. Next.
78. Oblige me.
May I please, your lordship? Madam, initial custody, my lord, 29/4/2024. 29/4/2024. And offense, my lord, 21B of NDPS Act, my lord. 109 gram of brown sugar has been sealed. No similar seal.
Yes, diary required, my lord. Yes, diary attested.
Enter certified copy. I have brought my lord.
Yes, sir.
109.
How many antecedents?
No antecedent.
Yes, diary is not there, my lord.
It's not there. Call for case diary next week.
Enter
Give
certified copy. I
case
brought.
diary. Without that, I can't give the bail. Case diary, yeah?
Next week.
Yes.
29. 79, may I please? I have filed the power malicious, but the present person is custody since 27/5/2024 malicious.
27?
27/5/2024.
24.
24.
Yes.
The present person name was not in the FIR malicious. Alleged offenses 406, 408, 420, 467, and 468 and 471. And
Charge sheet filed.
charge sheet has been 19/7/2024. 19/7/2024.
Yes.
My lordship, the present person was working as peon temporarily in the Indian Bank, Singri, my lordship. In the earlier, my lordship, in all, this is another, in all PS case number 63 of 2024, the present person is released on bail, my lordship. That bail application is there, my lordship.
Similarly.
In that PS case, my lordship, the present person name was reflected, but in the said all case PS case, the present person name was not in the FIR, my lordship.
Yes. What else? You repeat. You renew your bail plea. The charge sheet is filed.
My submission only. I am praying for my lordship that kindly consider the similar
You tell all these things to the trial court. A petition is agreed by the order dated 3/6/2024, whereby his bail plea has been rejected. Subsequent thereto, on 19/7/2024, charge sheet has been filed. In the changing circumstances, petitioner seeks to renew his bail plea before the trial court. If such-
kindly, my one submission, kindly consider this bail, the release order, the same type of condition imposing.
I have considered and rejected. Therefore,
No. So kindly consider, that bail application, my name was not in the FIR, kindly consider similar type of imposing similar type of property security, I will imposing.
Antecedents.
No. There is no other antecedents, he was that kindly.
Form part of
Kindly consider this a bail application, the similar I have supplied that release order, kindly
I consider thereafter only I am saying. During investigation, your bail application was rejected. Thereafter, the charge sheet is filed. You have antecedent. Allegations are like this.
And
I am not inclined to give bail. So therefore, I am giving that.
imposing any conditions,
I am not inclined. Therefore, I am saying it is a discretion of the court. I am not inclined. If I would have inclined, I would not relegate you. Straight away, I will give you bail. If I satisfied, I am not satisfied. What to do? Yes.
That application,
Next.
Permit to withdraw, kindly consider to
Withdraw leave. I have.
Withdrawn.
I have not made any adverse this thing. I have not rejected your application. You say, I said that in view of the changing circumstances, you want to move it to the
one line, on the said application, can considering the earlier the High Court's order that will consider that bail release order, the land court below will consider the same will be considered the release order.
All materials.
The
material available to the court and
release order. BLPL number 1135/24.
By taking into consideration the order of this court granting the petitioner bail in the in other case registered against him. What BLPL number?
1135
Yes,
of 24.
Yes.
Obliged.
Yes.
May I please, your lord?
Yes, sir.
The petitioner is in custody since 17/5/2024 in a protest petition, my lord, filed by the opposite party number 2, and he has already been noticed and appeared, my lord. In the similar case, my lord, the co-accused has already been released by my lord.
Similar or same?
Sir.
Co-accused.
Co-accused.
You are repeating.
I'm appearing for the offense, but we haven't been served a copy of the bail application.
Already sent it
Notice says that AD has not been received yet. So we are.
CD?
CD is
No,
not required, it is a complaint case. Complaint case.
Have you seen this? Co-accused.
We don't have a copy of the bail application.
Please give it Friday. Give this out Friday. Friday, take it. 81. 81 also. Both the copy you please give. Bail application as well as this also. Yes. 82. Bail over. Yes. Yes. 82. Which one? Which Dhal? Repeat it, huh? Let him come. Yes. Yes, sir.
Nobody yet. Cognizance, question of cognizance.
Oh, entry moderate there, so nobody will come. That's the problem. What is this matter? I'll vacate the entry. Yes.
Compromise matter, my lord. 307 is there. And
what is the service position? Opposite party number 2. July 2023 notice was issued.
18 sir.
Huh?
Nobody also appearing for the opposite party.
Matter is settled.
Not that is they have mentioned that matter has been compromised, my lord. But
what to do?
Paragraph 8, my lord. Paragraph 8.
Paragraph 8 of the
Petition, my lord.
petition.
Page 5. During pendency of proceeding before the court below, the matter was amicably settled between the parties.
What are the offences?
307 and other offences, my lord.
See, this is the problem. You take interim order, they don't come.
497, 307, 506, other offences there.
Well, on the ground that the parties have settled the dispute, the present petition has been filed for quashing up the entire criminal prosecution against the petitioner. Notice was issued when the matter was taken up on 27/6/2023. None appear for the petitioner. However, and subsequently, on 18/7/2023, the matter was argued partly, and notice was issued to opposite party number 2. Notice on the opposite party number 2 is sufficient. However, none appears for opposite party number 2 as well. The further proceeding in CT case number 942 of 2017, pending in the court of JMFC Toro, was directed to be remain stayed. Since the parties are not appearing today, I'm in the interest of justice, I'm adjourning the matter to November. However, the interim order passed on 18/7/2023 is vacated. Yes.
May I please? Yes, in this case, my lord, my revision petition has been rejected by the learned AD Salehpur only on the ground of delay, my lord. Like against
Ground of delay?
My lord.
Where is that order?
My lord, under Annex 2, my lord.
Yes. This was arising out of this Annex
1.
Your application for what?
My lord, the opposite party filed a petition under section 133 of CRPC before the AGM collector, AGM Sadar Katak. And against that order, I prefer the revision before the ADJ Saleh. And that has been rejected only on the ground of delay, my lord. And the delay was 6.5 months. Due to medical illness, the petitioner could not prefer the revision in time, my lord.
Achha. Show me relevant part.
My lord, kindly have a glance to page 15. Second paragraph. In the present case, the petitioner has filed the revision against an order dated 16/9/22, passed in criminal miscase number 2/22 by the Learned Sub-Divisional Magistrate Kotak Sadar. Therefore,
yes. Show me your revision petition. Where have you explained the delay? Where have you explained the delay?
Petition I have not done it.
Then how will I know how you have explained the delay?
The medical illness.
Show me. Unless you show me the application
that has been mentioned in the.
Where is your application? I am asking you. Your application for condonation of delay is rejected.
My lord.
Where is that application? I am not entitled to see the application which was rejected.
No, my lord.
Show me whether you have given.
I have not annexed.
That's the only application you are supposed to do. Your application for condonation of delay is rejected. As a result of which your revision petition is rejected. You have to show me whether you have given sufficient reasons explaining delay or not. Where is that application? Show me, give me that application at least.
That application is not with me, my lord. Kindly adjourn it to.
No, I'm rejecting it and
my lord, next week I will file.
Why should I waste time? Do you know how many people are waiting in queue?
Pardon.
Show me if you have right now. I'll read it.
No, my lord, that is not with me. my lord.
December, adjourned to December. December.
84.
In this petition, I don't know, 84, no, 83. 83, thila na? In this petition, a petitioner has challenged the order dated 4/9/2023, passed by the additional sessions judge Salipur, rejecting the revision petition filed by the petitioner on the ground of delay. When the matter was heard, on the query from the court, the petitioner submitted that he doesn't have the copy of the application for condonance. In the absence of a vital document, the present petition cannot be adjudicated. Hence, he seeks adjournment to file the application for condonation of delay, which has been turned down by the in the interest of justice, December before vacation, what was given, and in the meantime, let the copy of the revision petition along with the condonation of the application be filed.
Maybe
84.
84.
Notice the additional matter would not be issued.
No. Postal tracking report issued to open notice fact B.
Sufficient.
Notice sufficient.
But it is sent to mediation, my lord.
Already the order is there.
Yes.
Order is there.
Dispute between two brothers, my lord.
It was sent to mediation.
What is
mediation?
order 292.
Mediation is successful.
No. Appear करने से.
Okay.
Opinion number 2 has not yet appeared.
Served through the
serve notice to police.
Extra.
In course of the day, I am serving an extra copy.
Extra copy. Please
Yes.
give letter.
Today, in course of the day.
Despite sufficient service on the opposite party number 2, non-APS for the opposite party number 2. The matter was also referred to mediation by order dated 2/9/2024. For non-appearance of opposite party number 2, mediation also could not be initiated. Hence, the state, hence the opposite party number 1. Hence, Mr. Ragada, State Council undertakes to serve the opposite party number 2 through the IO of the present case. Extra copy of the petition shall be given to Mr. Ragada during the course of the day. And least up to next week.
Maybe.
So that we will send them to mediation. No?
Maybe pardon me, Lord. Milord's item 82, I missed the matter. I was there in 8081. I went to get the file. Milord.
82 gone, long way.
I was there in 8081. Milord. I'm limping. I went outside to get the file. Milord.
You be there outside for some time. Wait. It is gone, long way. What did I do?
Arjan Manor,
Milord, the compromise petition is on record in the CRLMC. It is filed along with the CRLMC. Milord. The stay order was vacated by the lower court.
I have vacated now.
It was already.
The way you first you file the petition, you don't come. Then you come.
I was there in 81. I was there in 81 Milords. The file wasn't. It was outside Milord to get the file. By the time I came back.
That is the reason I don't give interim. Once interim order you get, then all kind of ploys.
82.
What is this? I vacated already interim order.
Kindly.
Move application. You should know how to move an application for restoration.
A joint compromise affidavit has also been filed, Milords.
Where are they?
Plus, they may fix a date for the.
Why should I fix the date?
Plus, on the previous.
4 hearings you have taken.
Milords.
And you took an interim order, thereafter you evaporate. And today you say that it's settled. Where are the accused?
I'll produce him on the next date of hearing.
Why should I wait for them? After 6 days, 6 hearing, 5 hearing you have wasted?
Let me keep it to day after.
No, nothing to it.
Let me keep it to day after.
Next item.
85.
This is atrocious. You can't do this thing to the court.
Tomorrow I already added the in front of the opposite my lord. So tomorrow I added the in front of the opposite part number 2, my lord.
Tomorrow or yesterday?
Yesterday, sorry, yesterday.
Tomorrow. Tomorrow hasn't come.
My lord. And in front also appeared, my lord, to advocate, my lord. I pray Friday maybe to call for because both all are present under that, my lord.
Could not be issued a newly added affidavit due to no filing of a birth certificate.
It is already appeared, my lord.
Already appeared.
Why should you say that you have settled the dispute then?
No, already I filed the petition, my lord, for a compromise, my lord. And affidavit also there, my lord. They came yesterday, but due to that.
Serve them.
My lord.
Next week.
Friday, both are all are
next week.
May it please your lordship. Item number 86, my lord. Previously, your lordship heard this matter and issued notice to the opposite party number 2 and 3.
Just see the service.
The flag C and D is the postal tracking report, your lordship.
Address C could not be located.
My lord, the C and D are the complainant, and I will get the address and file it.
The counsel for the petitioner seeks one week to file fresh address of opposite party number 2 and 3, and let him furnish the fresh address and notice be issued on the fresh address.
In this matter, my lord, I filed one IA for stay of further proceeding. I am not pressing that application, my lord.
Past you, sir.
My lord, previous date, your lordship directed. I am not pressing that application. Also, I filed another IA for stay of the NBW, your lordship. NBW order passed.
Where is that NBW?
The NBW is at IA number 1946 of 2024, page number 7, my lord.
1946.
My lord.
And go and appear. I'll say this. Set aside this and go and appear, argue all the points.
My lord, what happened in this matter needs to be heard, your lordship, because this is a case where the police illegally foisted the present petitioners, my lord.
You argue on this point. I'll set aside the NBW order.
Bail reduction. It is a matter of, my lord, it is a matter of 2010. In the 2011, three number of accused are already acquitted, your lordship. I am another accused where the police.
I'll give you this indulgence despite the fact that NBW was issued in 2010.
My lord, but my lord, I am.
And 2010 you have been avoiding. You want indulgence of this court.
My lord, in the year 2024, I am appreciating your lordship, but in the year 2024, at the time of election, I not know that the case is initiated against me.
17/6/2010, NBW was issued.
My lord, I am not.
14 years you have avoided. Now you are coming and seeking quashing up for the.
My lord, I am not the habitual offender. I am not the culprit in this case, my lord. I will prove, your lordship. I am squarely covered with my lord's judgment, your lordship, past one judgment. That is 2024, volume 1, OLR 747.
You have been absconding.
My lord, absconding, the police said, my lord, it is absconding, but the complainant and the victim, they are saying, we don't know about the accused. The independent witnesses are saying, we don't know about the incident. No one is supporting except the IO.
You serve, simply. Let him serve.
Lordship, stay of NBW is required.
Why 2010 nothing happened? 14 years. Now overnight you have urgency.
My lord,
you could manage for 14 years, 14 long years. And you need a stay now. What are you talking? I'll reject the entire petition.
Your lordship, I will argue this matter. Your lordship may kindly post this matter after 2 weeks.
Better I'll quash the NBW, go and appear and argue all the points. I'll keep everything open to you.
Custodial in issue, my lord. I am a public servant, your lordship.
You serve them. We'll see. Yes.
87.
My pleasure, lordship. Lordship, 87, the earlier occasion, the matter has been settled, my lord, and one of the.
Yes, sir.
Hello. May it be yours.
Yes. What is the age of the
But it will be around 80.
Huh?
More than 80.
More than 80. You said that he is the father of one of the
Lawyer.
lawyer. So therefore, you want aiming at an acquitter. Yes.
But it's a case that petitioner, the appellant was working Orissa Forest Corporation Limited.
Yes.
As supervisor, and he was in charge of 16 coups. It is alleged that appellant and two others, those who have been acquitted, while they were working under Lathor subdivision under Orissa Forest Corporation, they were in charge of Chhatra Dandi's SWC coup. It was marked that some trees of the said coup, though were cut, but the logs were not found intact. But the two persons, along with the present appellant, those who were placed on the trial.
The accused number 2 and 3 were acquitted.
Yes, my lord. Peculiarity is, I want to draw my lord's attention that the sanction was also obtained for them. And if my lord will see the sanction order, which has been exhibited as Exhibit 9 to 10, my lord may kindly see.
Yes. Where is that? The
Exhibit
paperbook? In the paperbook it is there?
That is, well, not a sanction order has not been printed. It is available in page 42 of the paper book.
42.
Well, who PW10 has deposed.
Yes. Yes.
That he has passed order for under Exhibit 9 to 10, 3 sanction orders.
Yes.
Sanction order was given by the managing director, Orissa Forest Corporation. And out of the sanction orders, my lord, 2 persons, namely, my lord, Chetti Satyanarayan and Jyotish Chandra Behera, they have been acquitted.
Yes.
My lord will also see.
Sanction was granted in their favor also.
Sanction was also granted in their favor because the register says Chetti Satyanarayan was the assistant supervisor under me, and in fact he was in physical charge. But what happens in a forest coup? Trees were cut and they were stacked in position. It is practically impossible for a human being to guard the trees or the logs in question or the firewoods in question or to 24/7 24/7. That has happened in this present case. What has actually happened, even the investigating officer says that though the trees have been shown to have cut, but it has not really been cut because that marked trees are still available in the forest.
Okay.
Though it has been mentioned in the log that it has been cut, but it has not been cut in that process. Though the stock shows more, but in fact, it was not that. And also, before the present case was initiated.
Where is that part of the statement of IO?
My lord.
And that goes to the root.
That goes to the root, my lord.
Where is IO evidence?
My lord, that will be PW11, page 44.
44.
4. I do not know if prior to my conducting investigation into the case, there was an inquiry by a forest officer.
Where are you reading?
Paragraph 3.
Paragraph 3.
Where he found that although some of the trees were shown to have been felled and converted to timbers, those trees were actually standing. I have not visited the spot to verify the stumps of the felled trees shown to have converted to timbers and firewood. And in that respect also, DW1.
DW1.
Yes, DW1, my lord, may kindly say. If my lord will see the evidence of DW1 at page 45, my lord.
44.
There were 19 forest coups under my control. My lord, we see paragraph First paragraph 3. Chief. Besides the management of these groups, I was in charge of collecting salt seeds within my subdivision.
Yes.
There were supervisors and maids in all the groups. The assistant supervisors posted in those groups.
The DW1 means that
Is the
you have examined yourself.
Appellant.
DW1, my lord, the defense witness number 1.
315.
My lord.
Yes.
The assistant supervisors posted in those groups were in the physical charge of timber. According to the circular, I will also show the evidence of the ranger who says assistant supervisor in fact is in charge. Assistant supervisor who has been acquitted.
Right, let us focus on that part. If the trees were not cut,
My lord. I mean,
same tree. That portion you show me.
My lord. Trees were not cut and some firewoods were set to were got at fire, and that is there also because I have intimated my authorities under Exhibit A, B, C that is there in the record by writing letters that this has been done. This has happened here in the forest. Well, let me see.
Yes.
According to the circular issued from the Orissa Forest Corporation.
Where are you reading now?
See, same paragraph, my lord, chief.
Okay.
Unless I will read it to Toto, my lord, there will be no link. According to the circular issued from the Orissa Forest Corporation Limited, Bhubaneswar, accused Satyanarayan was the assistant supervisor in charge of Chhatra Dandi SWC Coup. He was responsible for felling, conversion of the logs of timber and firewood, and maintenance of all records of the coup. I will not.
Yes.
Paragraph 2, 4th line.
Yes.
Accused Satyanarayan has committed a mistake twice. Let me see. Mistake twice showing the conversion in respect of 15 marked trees for 24.7 cubic meters. It will be found at page 73945
and so and so.
And 73936.
Doubling.
The doubling was found for trees number 163. Similarly, the trees number 459, 600, 524, 412,
doubly
so on so on. Have been doubly entered into the log measurement book of the coup. Similarly, 3 other trees have also been doubly entered in this register. Accused Satyanarayan had mistakenly shown the measurement of the dispatched trees in respect of trees number 363, 448, so on so on, to an extent of 6.145 kilometers. The accused Satyanarayan has shown certain trees to have been felled and converted to firewood, though those trees were actually standing at the site. One SCF, one BP Singh IFS on spot inquiry has found those trees to be existing and has made an endorsement in the conversion register dated 9/2/83, volume 1 at page 3, 6, 12, 19, 25, 58 and at page 42 in conversion register
number 3,
volume 2. 3 of the species Arjuna, Khasi, Bahada, Makka, Kusuma, so and so
are soft.
They are liable to decay during the rains and other vagaries of nature. There was heavy flood in the year 1982. There was fire in the coup in the year 1983. The loss of timber was reported by me on account of heavy flood and fire. The extent of such loss was about 10 cubic meters. This is my original report marked Exhibit A. This is in respect of the loss of wood due to heavy flood. This is my original report of loss of wood due to fire marked Exhibit B. My report is based on the report of the staff.
Then three things. One is due to flood, some timbers were lost. Due to fire, some timber were lost, and the remaining there are doubling.
Some trees were there, but shown to have been
It's a doubling.
Doubling.
It's a case of doubling.
Doubling.
So that is what his defense is. And this defense statement recorded under 315 by the accused himself is supported by the IO statement.
Let me see the cross-examination also. Nothing has been said. And that too, Ranger has also said that Satyanarayan was in charge. The reasons best known to him, he has also not been accused, no evidence has been laid. And
what Satyanarayan is that accused number 2.
My lord.
Satyanarayana is acquitted. Yes.
My lord.
Chetty Satyanarayana.
Chetty Satyanarayana.
Yes.
Well, let me see. I just evidence of PW 3 and 4.
PW 3 and 4.
Well,
who are they?
They are my lord range officer.
4 is success.
Huh?
3 is range officer, 4 is success.
4 is success then. Yes, my lord friend has gone through.
Page 20.
29. 29.
My lord. I will draw my lord's attention to the chief also. Because, sorry, cross. I cannot give the area covered under Chatradandi SWC2. It was a very big coup. This coup is situated within reserve forest, Chhatrapati. Beyond the reserve forest, there is boundary demarcated with 3 trees marked in coal tar. There were standing trees of Chhatrapati's SWC. After felling of the trees from a coup, the logs are struck in the coup. There are instances of theft of logs from coup out of possession of the persons who has taken their delivery. I cannot say how many coups were under SDM OFC Limited, Lato Division. Accused Satyanarayana was the agent of this coup. The agent of the coup supervises its works for
The rank of agent is that of an assistant supervisor.
Cross-examination with regards to Satyanarayana is the rank of a coup agent is that of an assistant supervisor under OFC Limited.
And how Satyanarayana is acquitted?
No, 313 has also been done.
Here.
Yes. Accused statement has not been recorded.
Then it will vitiate the entire trial. Why should we read so many things?
Only the accused statement of the present appellant has been recorded, and these other two, they have been completely.
Why have you not recorded the 313?
Yes.
Is that the reason for acquitting them?
No reason has been, nothing has been said in the judgment.
What about your 313?
My lord, please see.
Page 24.
313 is at page 24.
26 is the relevant matter, the defense. Question number 10.
I have answered it, my lord.
24, huh?
My lord.
It starts from 24. 26.
Why have you not recorded the 313 of 2 co-accused?
Well, let me see question number 10. Will you say anything in this case? Lathor division the charge of Filabale, Contavanji, Lathor, duty range, so and so forth. Coup Mathila, regular staff Nothile, supervisor, Dujon, କୌଣସି ଚାର୍ଜ ନେଇ ଏନେ ପ୍ରକୃତରେ ଷ୍ଟକ୍ କମ୍ ନଥିଲା, ଫରେଷ୍ଟ ନିଆଁ ଖରାପ ବନିଥିବାରୁ କେତେକ ନଷ୍ଟ ହୋଇଯାଇଥିଲା, ଗଛ ମାନ ଥିଲା, ମାତ୍ର କଟା ହୋଇଥିବାର ଗଛ କଟା ହୋଇଥିବାର ଦେଖା ଦିଆଯାଇଥିଲା.
Where can I get that 313 of co-accused persons are not recorded?
It's not there. Not there also.
But recorded or not there is one thing. Recorded or not.
If it would have been recorded by Lord, office will not commit that mistake. Office will not commit that mistake.
Need to check the LCR, whether it is available in the LCR.
See, I'll tell you, if there are 3 accused put to trial.
Yes.
One accused 313 is recorded, and you don't record the 313 of other 2 accused persons. They were acquitted on other ground. That's a different thing. The entire, according to me, the entire trial is vitiated. I need not go into anything. I'll acquit.
Well, the person who is the principal accused over here, his
principal accused is Satyanarayana. That's the statement of your own range officer.
That is the defense of the appellant. It's not that.
No, range officer. I read PW1, PW3.
Here the allegation is all about misappropriation.
He was in charge. Satyanarayana was in charge.
No, it's not that. I will come to that.
My lord and friend wants to show the evidence of PW4 who was taken charge from me. My lord, I will also.
Because this
yes, I'm coming to that. I'm coming to that. I know you take advantage of that.
But I must tell you, Mr. Rijvi, we are trying to find out way to acute. Don't create problems. Try to assist so that this matter you know.
Yes,
this matter judgment was reserved.
Yes.
We were thinking of giving probation of offender check, but in PC we can't give it.
No, TRC also.
Then we thought TRC. TRC was not possible. He is now 85 or 86.
Yes. Well,
So
in
therefore,
that, well, it's in that
and
case-
he is the father of an lawyer. So therefore, the other matter we have done it.
Yes.
But he is
Well, in that
aiming
case,
at-
my lord, I will not submit. I will just give a written note of submission.
Yes.
Because my lord,
Some-
he has accepted to receive this misappropriated timber and that stack of wood.
What
from the
about
successor.
what about the defense? Has it been dealt
No,
with by
and
the
what defense what he's giving that exhibit A and B.
Huh?
Exhibit A I don't want to comment, but exhibit B is undated. So it's all manufactured thereafter after this case was filed. This is in my respects of
But IO says that the trees are standing.
well, trees are standing or not, that's a different issue altogether. Thing is
That's the
that-
only issue.
No, it's here.
If the
No,
tree
no, my
fell,
lord.
then the timber comes.
No, my lord, solid trees are turned into timbers. Hollow trees are kept for firewood. So standing or it's sleeping, that's a different issue altogether. Because here we need to see the available stock of timbers that has been taken charge of this present appellant, whether which was totally under his dominion, how far he has discharged his liabilities and duties. Because 409 is there.
Yes. Let us see the reasoning of the High Court.
My lord,
Yes,
take
ma'am.
LEC,
Only for-
paragraph 6.
Page
Page 13.
13. ma'am. What is the only reasoning?
On the question of entrustment.
Yes, ma'am.
My lord,
Yes,
I will also draw that. My lord, 6, 7, 8 lines. Exhibit 3 was the coupe delivery challan in which accused Sri Buduli had acknowledged to have received the marked trees for their felling and converting to logs as per his signature, Exhibit 3/2. Well, got it?
Yes, I am there.
Not only
Not
did-
only did he
Yes,
himself.
Not only did he himself do the work, but also he made application to the concerned DFO Balangir territorial for appointment of accused Sri Chetty Satyanarayana as an agent to do the operation as per Exhibit 4, which was recommended by PW3 to the DFO Balangir. If he has done so, and he was appointed as agent without assigning any reason, without recording the 313 statement, it can also be done. Law says if no material forthcoming, 313 may not be recorded.
That is why I put it.
There must be an order.
But materials are there, therefore I am
Yes,
saying.
material is clearly there. Well, let me
Materials
see.
are there.
And
It's
here
even if one witness have said anything, that has to be put to the.
Well, here the prosecution could not further prove the action taken by the accused Chetty Satyanarayan in this connection, nor even the accused Buduli proved anything to show that accused Satyanarayan took charge over the trees, felled those and converted those to timber. That I have stated in clear and loud terms in my defense, my lord, under the TW1. This witness had no business to entrust the coup in question to accuse Chetty Satyanarayan. SWC 2 Chandradandi Coupe had long since been demarcated by their forest department. The DFO Valangir in Exhibit 5 had issued a letter to the OFC, the Limited Kontavanji, that Chandravadi SWC Coupe was given to OFC Limited for operation. That is not important. Exhibit 3 is the coupe delivery certificate given by PW3 to this accused, who was shown 755 numbers of trees for felling and 228 trees marked for retention. This evidence has completely established the fact of entrustment. That court says, but it is not there in any evidence. Well, at the period covered in handing over and taking over charge between them was from 5/10/83 to 7/10/83. The charge report prepared and signed by both the officers was marked as Exhibit 6, in which accused Buduli has signed by Exhibit 6/2. A detailed charge report is placed in record. Accused Buduli did not make charge of timber measuring 77 and odd cubic meter and firewood numbering 137 stacks of size 6 inch to 6 into 3 inch. This witness was definitely asked to answer whether he had taken physical charge of the stock or not. His specific answer to this question was that he verified the stock actually and physically at the time of taking over the charge from this record. That is not important. Important is page 15, 7th line. As per physical stock verification report, Exhibit 8, there was a shortage of 137 stacks of firewood and 95 cubic meters of timber. This report was submitted in the prescribed performer. The presence of accused K.C. Muduli was tried to be excluded during the physical verification of the stock by way of a suggestion to this witness, which he was denied. Accused Muduli, examining himself as DW1, has proved 2 letters, Exhibit A and B, showing destruction of timber by fire and flood water. Damage caused to the timber was not to the extent that has been found sought by the prosecution, but around 7.543 cubic meter timber were destroyed this way. When he wanted to apply responsibility on accused Satyanarayana, he should have obtained a report from him about such damage caused to the timber, but instead he obtained a report from one Jyoti Chandra Behera as per Exhibit B by 1. However, the damage was not so much as against the claim of the prosecution. The learned counsel for the accused Muduli has relied on a general circular issued by OFC Limited, Bhubaneswar, by dated letter number so that the accused as the SDM had no concern over any stock, but it was the Munshi or assistant supervisor. Assistant supervisor was Satyanarayana, who was responsible for the stock. Circulars are issued for, but it seems the entire tenor of the judgment is as if court is arguing for Satyanarayana. Why don't you see? Here the circular says assistant supervisor is will be held responsible. He says circular is for circular. It is not to be carried out.
Thereafter,
circulars are issued for departmental use. Those are not always strictly adhered to. The duties and responsibilities of field staff like accused Muduli has been indicated in the circular, but this is concerning forest works only. Forest works means operation like felling of trees, converting the felling trees to timber, stacking of timbers, firewood, sale and transport of the timber and firewood, etc. If actually the accused Muduli were not in charge of the stock of timber and firewood, it would not have been necessary for him to make overcharge or physical stock of the main same to PW4. When he has done so, the natural inference would be that he has entrusted with the stock. That is the reason ascribed. That's when I have
giving and taking has taken
over.
place, so
Yes.
therefore
I entrusted.
handing over of the charges.
Yes,
That's what
he has acknowledged the same.
and that is contrary to the circular.
But he accepts.
Contrary.
But the circular very specifically says
That has been further clarified what forest works means, my lords. Very same page 16. Forest works means operation like felling of trees, converting the felled trees to timbers, stacking of the timbers, firewood, sale and transport of the timber
and no
and fire.
discussion about the third accused.
now, what the circular, do you have the circular on record?
No, it's not on record. Well, forest work means it includes whole gamut of things, my lord. This is what he has, the judgment said. Forest works, in fact, means, my lords, like felling of trees, converting the felled trees to timbers, in the present case, stacking of the timbers, firewood. Now here the moot question is misappropriation of 1.37 stacks of firewood and timber. 1.37 stacks of firewood.
7 stacks.
And timber to the tune of 95.8210 cubic meters.
95.8210
cubic meters. That will amount, my lords, to rupees 1,29,000 in the year 1996.
Huge.
Then your lordship may kindly come. I will just take 2 to 3 evidences, my lords, of the range of it.
Yes, let him come. Yes.
Yes, well.
Yes.
PW3. As drawing my lord's attention to evidence of PW3.
Where does it records the acquittal of these two?
Say, my lords, page 16, last paragraph.
In that, after discussing the evidence,
Yes.
record,
Just before that.
Yes.
The prosecution could not establish the last fifth
Through
line.
evidence that the other 2 accused persons had anything to do in the matter of remaining in physical charge of stock of timber and firewood, and they played such role in respect of the said stock. I find absolutely no reason.
There is no exhibits to the
He
effect
says that there is no entrustment to them.
Exactly.
So therefore,
And there is no exhibit in record which will establish that Satyanarayan was in charge of these stocks, timbers and
he says that it is the accused who has been entrusted.
Yes.
And there is a misappropriation found.
And
He is responsible.
And also the appellant acknowledges this fact that he has taken charge of these timbers and stack of.
So therefore, the circular was disbelieved.
Yes. And
It
the
seems parallel-
exhibit A and B.
I'm giving a small example. But if somebody must be in charge of vigilance section here in the High Court, the superintendent of that section is supposed to look after all the briefs. If some briefs are absent and A, B, C, D were entrusted, the entire responsibility goes to superintendent. What my 120 version of
Come to now 313. Regarding entrustment, what is the question put to this accused? If you have not put that question, that cannot be taken.
24.
Show me. Regarding entrustment.
Question 1 itself, my lords. Question 1 itself. Page 24.
Question 1 is not that. He has stated that he has
Delivery
read.
of trees, my lords. This is regarding delivery of trees. He says yes.
PW3 has stated
Yeah.
that he as the range officer, so gave you the
SDM OFC Limited, Lathar subdivision, delivery of the trees as per the CAM delivery certificate.
Exhibit 3. Exhibit 3 is the question.
Yes. Which you have received under your signature. Which he has received under his signature 3/2 minutes. Exhibit 3/2. He says yes.
Entrustment.
Entrustment.
My lord, may kindly see question number 5 and 6.
Yes.
He has stated that the shortage of timber under your charge was 77 and odd cubic meters. What you want to say? He has stated that you reported that 137 stacks of firewood under your control was washed away by flood water as per your letter number so and so. The letter was much prior to in the initiation of the case. What you have to say? PW8 has stated that he conducted physical verification of timbers and firewood under your control on 6/11/83 for stocks as on 31/10/83 as per Exhibit 8 series. What you have got to say?
Again,
He was not there.
But you are not doubting the entrustment. You are rather
as supervisor.
Yes.
But it was
as supervisor.
Accounting problem. There was accounting.
Yes, accounting
problem.
Entrustment is not doubted.
How can it be? But if you would have said no, I was not in. I had not received anything. He was supervisor, and appellant number 2 was assistant supervisor, and third one also assistant to him. As supervisor, he has done his duty. When something has been washed away in flood, he has drawn the attention of the authorities. My lord can visualize what is happening in forest areas. Nobody is there. Nobody is there to look after anything.
No, whatever a
person
calculation you are showing, if that is taken into consideration, what will be the remain? The entire thing is gone.
No,
not the entire thing. Many things has been seized, my lord, as per the entrustment to PW4, when I hand over the charge to PW4, I handed over certain things, my lord. Some woods, some logs were absent.
What is that demo?
That is, my lord, we see PW4.
That is that 94 cubic meters.
That is the
and
difference.
if at all accepted.
No, if his defense is accepted,
For the,
even then, if you
even then, my lords, he says the destroyed wood was to the tune of 7.543 cubic meters.
And department has also not done.
And taking that figures into consideration, still 88.278 cubic meters of timbers are still left in his custody. Even if we accept,
even if they accept the defense.
Yes, even if we accept the defense, still there is no shortage of 88.
It's a fact.
It is on record, my lord. These things are on record.
If my lords, logs are stacked in our house also, 3 days after, you will see one log will not be there. Ki regalani agara
And
odia
if at all we accept this loss as per Exhibit B, whether Exhibit B can be accepted, which is undated.
Let me kindly see evidence of PW4, which my learned friend is helping a lot. But let me see.
Page
I
32.
took over the charge of it.
I took charge of
From Kailash.
on 124,4190 cubic meters of timbers from so and so. I did not take charge of an firewood of the stock was nil. As per conversion register, a stock of stock of 201,7010 cubic meters of timbers would have been left after deducting the transport materials from felled materials. The surface of timber, therefore, was 77 and odd cubic meters. The stock of firewood would have been 137 stacks of so and so, which was alleged to have been washed by
Flood water.
Flood water, as reported to the divisional manager by letter number so and so, cross-examination. The other accused persons are the employees of OFC Limited, Lathur. There were about 12 coops of SWC type under SDM, so and so, Lathur those days. The surface was only in respect of SWC coop number 2. Accused Sri Satyanarayan was the assistant supervisor of that coop, and accused Sri Behera was the mate of that coop. How can they be completely given a ghost cheat ballot, and my learned friend is supporting the same? I don't understand. Our forest corporation used to get delivery of the particular area of the jungle to constitute them to a coop and SWC CS. In that coop, the forest department marks the trees, giving numbers for felling. This is done for a particular period. During that period, the corporation caught the trees marked and sends the timbers for sold. In case the corporation cannot cut the trees marked, the corporation forfeits the rights. The corporation pays a royalty to the state government to get the coops. But this is the reason why they are showing it to be cut. In fact, it was not cut and solid trees. After cutting and converted into timber and hollow trees, firewood, the seized registers were maintained by accused Satyanarayan. There the entire crux lies better. If the stock will be verified, if this entire register will verify that was prepared by Satyanarayan. There is a circular governing the duties and responsibilities of the employees of Forest Corporation Limited. The duties of the assistant supervisor and Munshi, as per the circular of Orissa Forest Corporation Limited, are conduct of felling, lodging, so on, so construct, extraction, maintain field register, remain responsible for stock, check up record, buster sold. It is not a fact.
This is very important. Remain responsible for the stock.
But when 3 persons are there, I will not be held solely responsible for the stock.
And this is the responsibility of assistant supervisor, who is Satyanarayan.
And met.
How the court says that there is no evidence?
And no discussion, not a single line with regards to Mr. Behera.
Because there is
And I'm coming to that. It is not a fact that I have not actually verified the physical stock of timbers with reference to the accounts maintained as per the registers, and that in fact there was no shortage of timber or firewood in the department of OFC Limited. Later, I do not know whether the SCF had taken physical stock of the marked trees in the coupe and found that 20 number of marked trees were still standing. Well, let me see. Found that 20 number of marked trees were still standing. They are evidence valid.
I will still reiterate. We are not on the point of the trees which are standing. We are on the point.
That has been shown to have got.
We are on the point.
If the part of the tree which you are standing, and you are counting them.
No.
Yes.
Not counting
yes.
them.
Yes. That
if your lordship may kindly see the charge which he has taken from the successor, he acknowledges
that is PW4.
Yes, my lord.
Say, my lord, I have got stock of 10 things, 10 pens.
See, but one thing is very startling.
Yes.
You read PW3, you read PW4, you read IO statement. All these witnesses have said that the Satyanarayan is responsible.
But as
And
far as-
trial court straight away in one line says there is no evidence, no 313 acquitted.
Why, my lords? The reason I am saying,
Why?
there was some communication regarding the appointment of Satyanarayan. I doubt whether that has seen the light of the day. Your Lordship may kindly come to the evidence to that effect, my lords. There was some communication.
What?
This person
What communication?
wrote to the DFO to appoint Satyanarayan as the agent, but that has not seen the light.
No,
of the day.
if a witness.
So Satyanarayan does not come into the picture at all, my lords.
Then if this
cross-examination court, accused number 2
and very specifically says Satyanarayan was responsible for the stock.
My lord,
Will
he
you
does
not
not-
put it- will you not put it in 313?
It cannot be read in differentiating manner like
Just see,
stated.
come to page 33.
Yes, my
Fourth
lords.
line, accused number
Duties of assistant employees of Forest Corporation Limited.
Yes.
The duties of assistant supervisor and Munsif, who is Satyanarayan. Satyanarayan, as per the circular dated shown, so is all list. In that list, remain responsible for the stock.
Yes.
If that is the case, then this is a direct evidence against Satyanarayan. It should have been put to him in 313.
Because why,
What
my lord,
prevented the
Satyanarayan
trial
was
court to do
acquitted? Because no entrustment was proved as far as Satyanarayan is concerned, my lords. It is on record as far as the entrustment of this present appellant is concerned. The Lordship may kindly come. Well, only 2-3 evidence I will take, your Lordships.
What are the charges?
Yes.
Page
Against all of them?
23, my lords.
23.
Page 23 is the charge.
Yes.
Okay. Come to 23.
5-1C read with 5-2.
3 persons have been.
I want C for that entrustment is not essential.
Ballot
This
basically.
is for 409.
Ballot 3.
409 is
And
there.
then you are
409
taking,
and 34 both are there.
then in that case, then 313 was very essential.
But 313, as far as the appellant is concerned, it has been recorded, my lords.
I am only aiming at this thing whether the trial is vitiated.
Ballot may see
following
these
right
charges
process.
against 3 persons. By
If the
30
benefit of doubt can be given to Satyanarayan, why not to this man?
Because, my lord, Satyanarayan has not taken the charge of the timbers and the stack of wood. That is the reason. Because it is on record. If your Lordship may kindly see Exhibit 6, that is the charge report. Lordship may kindly see the charge report. Exhibit 6. I am not having those exhibits.
Have you filed appeal against Satyanarayan? No.
No.
It's 96, my lords.
Yes.
Because, my lords, the Exhibit 6, this is the charge report, my lords. It expressly says that this appellant has taken under his custody the remaining timber woods and all those things. The Lordship may kindly come to again the evidence of page PW3.
PW3.
Yes, page 29.
Yes.
May I just place it, ma'am? This is the range of.
Yes.
Lordships have it, madam?
Yes, I am there.
I was the range officer Kantabanji on 2012-81. I served as such for the years 1981 and 1982 under Kantabanji range. Chhatradandi Coup was under my jurisdiction and control. This is important, my lords. I gave delivery of the trees marked by us standing within the coup to accused K.C. Mudali, the present appellant, the then SDM OFC Limited, Latur Division. I prepared and signed this coup delivery certificate. This is Exhibit 3 and this is my signature marked Exhibit 3/1. I know the signature of accused Sri Mudali, who had also signed here in my presence. This is his signature marked Exhibit 3/2. Entrustment. This is the application of accused Sri Mudali signed by him. This is marked Exhibit 4. This is his signature marked Exhibit 4/1. I recommended the case and the BDO Bolangir approved of the nomination. Then your Lordship may kindly come to the evidence of PW4, the successor, page 32. Page 32, minutes.
It seems, my lord, they have
I-
targeted the present appellant,
Sir, kindly
giving a
come.
complete go by to the case against the other 2 accused persons.
Sir, kindly allow me to come.
No, I'm allowing you. And my lord, only thing which we have brought through cross-examination, that is, my lord, against Satyanarayan or the other Mr.
I'll-
Behra,
I'm just-
or else, my lord, they have not whispered a single word against the other 2 accused persons.
My lords, page 32, my lords.
Yes.
I took over charge of,
Designed.
my lord, he is the successor, my lords. He has taken over the charge. I took over charge of SDM OFC Limited Latur subdivision from Kailash Chandra Mudali, accused from 5/10/83 to 7/10/83. This is the copy of our charge report of making over and taking over the charge of SDM OFC Limited Latur marked at Exhibit 6, which I was relying upon. Exhibit 6 is very important, the charge report. This is my signature marked Exhibit 6/1, and this is the signature of Mr. KC Mudali signing in my presence marked Exhibit 6/2. I took over charge of SDM Latur after physical verification, my lords. This is important. After physical verification of the timber and firewood and other properties available in the depot and office, I took charge of 124.4190 cubic meters of timbers from Chhatrarandi HWC Coop number 2, and I did not take charge of and firewood as the stock was nil. As per the conversion register, my lords, this is important. They maintain a register when the trees are felled.
Stock of 201.
Yes, a stock of 201.701 cubic meters of timbers would have been left.
Would have been.
After deducting the transport materials from felled materials. So, my lord, this figure comes to 201 minus 124. It comes to around 77.282. And he says, in the
But he took charge of 124.
Yes.
Minus from 2.
Instead of 201, he took charge of one.
Minus.
Yes.
You minus it.
Yes, I am minusing it.
Minus it.
Yes.
Yes.
Then, my lord.
It's not a civil case. It requires appreciation of evidence.
My lord.
And while appreciating the evidence, my lord can think of two things. Yes, I'm admitting what my lord and friend says. Say 200. Why 77? Say 277. The record shows that I have given charge of 277 because I believe my assistant who has prepared the record as per the evidence of PW4, Satyanarayan was preparing the record. I believe him. Definitely to do a big work, my lord, I have to rely on my juniors, my associates, my friends. He has relied upon Satyanarayan. When a case was registered, definitely he must have thought of why this defect. Beforehand, he has drawn the attention of the authorities with regards to losing of fire, losing of woods by fire or by flood. That has also been said by PW4. Around some logs have been left out, marked, say, tree number 1. It has been shown in the register, but has not been cut. If a tree would have been cut, around 10 CFT would have been brought. 5 CFT would have been brought from that. Similarly, what he says, I do not know whether SCF had taken any physical stock of the marked trees or not in the coop and found that 20 numbers of marked trees were still standing, although those were shown to have been felled and converted to timbers and firewood. And I have given the numbers, whether the numbers which I have given in DW1, that has been verified by the investigating officer. Putting blame on a person is very easy. When I have categorically said that it will be found at page so and so, doubling found for trees number 163, 459, 600, around say 30 numbers have been given. Whether that has been checked by an investigating officer, my lord. Putting a person
as far as coming to the
criminal
position of the
allegation.
stocks, my lords. Position of the stocks, your lordship may kindly come to PW9. A physical verification was done in order to ascertain the figures, my lords.
33 top, just see, 33 top. The shortage of timber, therefore, was 77.
Yes, my lords.
And
that is
odd cubic meters.
That is what the calculation came, my lords. Because
and the stock of firewood would have been 137 stacks of size so which was alleged to have been washed away by the flood and water.
I'm grateful, my lord, because this figure of 77 has cropped up by
the 77 is not explaining.
201 minus 124, my lords, the pre-page, which we were discussing.
Where is the evidence to show that you have taken into account the tree which was standing?
The charge report, my lords. The charge report, he says he has accepted this amount of timber wood and stack of woods. Exhibit 6. Now, Lord, kindly come to page 34, my lords, for a moment.
Therefore, the problem is just try to understand who was maintaining the record. Satyanarayana. He can't go to every in the village, the forest, keep on seeing which trees fell, which trees not fell. He has to believe the record maintained by his assistants. And the assistant had maintained a record saying that this tree is already cut. On paper it is cut, but physically it is not cut. When it was verified, it was found that those 20 numbers of trees are there. So it is not a case for benefit of doubt.
Peculiarity by Lord and Friend is relying upon the evidence of
The
PW4.
good question is regarding the stock, not about how much trees were standing, my lords. How much stock he has received
Whether
from his
the
successor.
trees which were standing
Yes.
were factored into the account of the tree which was felled or not. You tell me, answer it.
Lord,
Have you factored it?
My lords, that is the reason I was taking your lordship to the PW.
So therefore, in that light, the co-accused Satyanarayana's role assumes importance.
But
Because it has ample evidence has come to show that Satyanarayana has been maintaining the record. And you have acquitted.
But has he taken the entrustment on him? Who has taken the charge of this?
Entrusted on paper, relied by the paper prepared by Satyanarayana.
With due respect, we all have to go on evidence on record.
Yes, evidence on record clearly. My lord, he cannot.
Lordship, kindly come to PW9.
My lord and friend cannot breathe hot and cold at the same time. When he is relying upon PW4, he should rely on PW4 in entirety.
Yes, ma'am. PW9 for a moment.
Who is he?
My lords, he is the manager OFDC.
Manager.
Yes, manager OFDC. He has conducted the physical verification. This is very important, ma'am.
I conducted the physical.
Yes, I was the Deputy General Manager OFDC Limited at Kantabanji Depot in 83 and 84. I received this letter so and so from the Divisional Manager OFC Limited Kantabanji for conducting physical verification of stock of timbers. My lord, this you kindly appreciate. And firewood in coop number 2 SWC Chhatrabani. Accordingly, I conducted the physical verification on 6/11/83. I submitted the report of this physical verification to the Divisional Manager OFC Limited Kantabanji Division on 19/2/84 in proper pro forma. The physical verification was conducted for the stock as on 31/10/83. Because here one thing I will point, successor has taken the charge on 5/10/83. So this physical verification has been done after that. The tenure of the coup was over and therefore no stocks were received in this report. This is my pro forma report marked Exhibit 8 in connection with this physical verification. This is my signature marked Exhibit 8/1. This is the detail of the stock position prepared under my supervision marked Exhibit 8/2.
He say that there is a shortage of
Yes, my lords.
77 cubic.
There was shortage of timber and firewood in this scoop number 2 SWC Chhatrandi, and as I found after the physical verification, there was shortage of firewood to one extent of 137 stacks of sites.
That is there, but very 77.
And that of timber to the extent of 95, my lords.
That's the problem. He says 77. Physical verification find 99. And other witness comes and says that trees are standing.
Their witness.
What is this?
On the same breath.
Benefit of doubt. Benefit of doubt. All the witnesses are, see, this is a case, and Satyanarayana, you should have filed an appeal against Satyanarayana. You have not conducted 313 also.
It seems that they are having to.
Direct evidence comes against this thing. And I'll just request you give a short note.
My lord, item 102, my lord, pardon to.
Whenever you give a short note, which portion PW3, PW4, PW9 and PW11. Relevant part is
and one also.
But and if you want to give,
Definitely, my lord.
In the case of benefit of doubt.
But if lordship permits, there was some misappropriation.
There is. See, we are aiming at acquittal, therefore. Otherwise, safe to convey, no problem. But you can create a doubt. Looking into the overall this thing. Had the Satyanarayana would have been convicted, then he would have been a difficult case. Now everything is shifting to Satyanarayan. Obviously, safest way of doing it.
They made up their mind from the beginning to give a clean sheet to Satyanarayan, then target this one.
We always go by records, my lord.
But this is a case. This is a case. It should have been remanded back. Had it been a conviction near past, because 330 ought to have been done insofar as Satyanarayan.
Absolutely correct.
You can't do it. It should have been a case of remand. But at this stage, what remand after the 30?
If a lordship permits me, at the end of the day, my lords, my learned friend has not left any stone unturned.
And he is absolutely. He has done his job.
Is there 107?
1 minute, sir. Yes.
107 letter. Release your cash. I have instruction because.
That 25 lakhs.
No, in fact, that was a
And I propose. My senior is saying, I'll obey.
No, in fact, there was a negotiation and a discussion. Acting. Sure,
Friday.
we have reached a truce, my lords. Only thing is, lordship at
Friday.
Tomorrow or Friday.
Friday.
First case.
Friday means day after.
I'm hopeful.
Fresh admission.
I'm hopeful.
Friday.
Lords, item 102, your lordship.
107, my lord. 109. Let it come. Friday for
109 weekly list. 109. Let it be there.
My lord, 102.
105, my lord.
Next week we.
My lord, 105, my lord. My lord, 105, my lord.
Senior. 1 minute. 1 minute, senior.
There's an entry order staying the entry maintenance rather to provide.
This will spread over next week. Yes, spread over. This week we will spread over the remaining matter.
My lord, 105, my lord.
Senior is appearing. The market said that.
We're fixing a date. He'll adjust and fix. The remaining matter will be spread over within 2-3 days.
My lord, that is the
entry order will continue.
My lord, 105, my lord. I am not there for next 2 days, my lord. Can it be next week, my lord?
105 adjourned.
My lord, 102, your lordship. Permitted to withdraw, my lord.
10?
Withdraw.
1 minute, very important.
Permitted to withdraw, my lord.
He's withdrawing.
Yes. 102, my lord. 102 item.
105.
102.
106.
5 and 6.
90. My lord, 92, my lord.
My lord, 102, your lord.
Tomorrow.
Beg your pardon, my lord.
92 kya book raha?
My lord.
Weekly will remain, sir. Weekly left to weekly.
Beg your pardon, my lord. My lord, beg your pardon.
Yes. Yes. Yes.
Her matter is in item 104. However, it has not reached.
No, it will be tomorrow day after any time it will come.
My lord, please just one minute.
1 minute.
My lord, the problem is on Friday and Monday I'm not staying.
Okay, Tuesday?
Tuesday is fine, but or tomorrow or Tuesday.
Tuesday.
Yes.
My lord.
Tomorrow may not reach unnecessary.
That's also specific time ta kar dena 2 टा 3 टा tar sorry bhai say jaha whatever the result ta sar daba
Morning, and that Tuesday you mention in the morning so that I'll take up because it's urgent case. Please mention Tuesday morning. Okay.
My lord, 104 item. I have filed intervention petition.
Interim?
Intervention petition.
Intervention. I'll hear the main matter.
I already filed yesterday.
See you.
They come with
That's item 80.
My lord, a big question comes as the locus standi of this person who has filed this intervention petition. That is to be taken care of. Yeah, exactly. In this matter.
In this case, I am for the petition lordship.
Who are you? Why should in the personal matter?
Exactly.
Who are you?
Exactly. It is a matter of
this is
maintenance.
Between a lady who is a lawyer and the boy is also a lawyer. And why are you intervening? Creating problem for that?
My lord, I am the wife of my husband. Already married the UP number 2.
So you settle your dispute.
That's a dispute. That's a different place.
Exactly. Very unfortunately, lordship, what happened in this matter, lordship? Very unfortunately, the counsel who was appearing for the OP2, why people and family judge, now became husband. That is the matter, lordship. That's why.
Whatever.
He is also a lawyer.
Whatever, my lord, whatever the facts may, that's a different issue.
Tuesday will hear. Why? I have referred it to mediation. It's not working out. All three of you are.
It is last date only you assigned me, it is by order of this
Now
honorable.
a very respectable lawyer is there.
I have gone through all the aspects.
One minute. You please.
When you are talking, I am not talking. Just, it's not a TV.
Please listen to him. He is amicus curiae of this court. He is not representing a party. And respect his seniority. He will give you right guidance and try to go by his guidance. Don't argue on merits. It will be difficult.
Well, item 89 may be tagged in the weekly for hearing. 89.
89.
Yes.
100.
May paid for Tuesday, my lord.
Two?
Item 91, my lord. They paid for Tuesday.
91 what? Will you come?
Paid for Tuesday, my lord, next week. Any day next week.
Next week it will be.
101, my lord. There is an empty order.
I am not doing anything. It will be spelled over to next week. Anytime.
My lord, item 102, your lordship. Permitted to withdraw, my lord.
102.
I'm at item 103. Your lordship fix the matter to mediation center. Now again the matter fix on mediation. The matter is posted to
Awaiting
24th.
mediation report.
24th. So your lordship, the matter may be the date may be.
I understand it. After 24th, it will be reset.
The interim order to be continued.
Yes, I know. I understood it.
I am for the opposite party.
That time should like that.
In this case, my lord.
Beyond 24 karte na interim order.
In this case, my lord, I am for the opposite party, my lord. In this case, my lord, your lordship has directed order dated 2/80/24, my lord. 10,000 rupees expense cost my deposit rate. Till today, my lord, he is not.
Tell in the mediation center. Mediation center, he will pay. What is the problem? Yes. Any mention? Yes, sir. Any mention?
Item number 97.
97. Yes.
It was specifically adjourned to today.
Let it be there. Next week it will come. It will spill over to next week.
Interim order to continue.
Interim order. I am not taking it up, so therefore there is no.
Yes.
Thank you.
Right. Item 1.